Meeting to order, 10:01. Believe we're going to start with roll call. Anna, do you want to do the roll call?
Yes. Thomas Griffin,
Present.
Jimmy Zulke,
Present.
Kyle Jackson,
Present.
James Spears,
Present.
Tasha Mora,
Present.
Gary Hoffman, Mr. Hoffman,
Can't hear you, Gary.
Can you hear me now?
yes, perfect, thank you.
Okay, I'm sorry, my deal's acting up. Yeah, present.
Charles Rash,
You're on mute, Charles.
Present.
and Miss Ken Ulmer,
Present.
and Miss Amy Milstead, presiding officer.
Present.
We have a full quorum.
All right. We'll move forward to item C, approval of minutes. Have all you board members had an opportunity to read over the minutes?
We have, and I'll make a motion to accept those minutes.
Okay, I have a motion. Do I have a second?
I, Tasha Mora, second.
Okay, any more discussion? Any questions on the minutes? Okay, motion carries. Minutes are approved. Yes,
We
ma'am.
will need to take a roll call vote for that.
Okay.
Thomas Griffin,
Aye.
Jimmy Zulke,
Aye.
Kyle Jackson,
Aye.
James Spears,
Aye.
Tasha Mora,
Aye.
Gary Hoffman, Charles Rash,
Aye.
Ken Ulmer,
Aye.
and presiding officer Amy Milstead.
Aye.
Motion passes, ma'am.
Okay, thank you all. The next item is D, public comment, and I think you all got copies of that. We're going to take their public comment when we get to their item that they want to discuss. I do believe that one of the public comments is not available, won't be attending, so you have those. Hopefully you've read them all, and we'll listen to them when they come up. That's going to take us to item E, staff reports, licensing division, Laura Hernandez.
Good morning, board members. My name is Laura Hernandez with the Licensing Division. I provided some licensing statistics for the TOW and VSF programs. They include both the company statistics and the individual licensee statistics. They're going to be for all of fiscal year 2020 and then the first quarter of this fiscal year. The population numbers really haven't changed much from the fiscal years. Also part of the report is also current projects, which we are currently trying to gather a statistics for you for the number of web contacts that we receive from both the TOW and VSF programs. So you can see how many customers go directly to our website and send us requests, whether it be to from license status to deleting trucks to just general questions, and be able to provide those statistics for you for hopefully the next board meeting. And I can address any questions that you all have regarding my report today.
Any questions from the board? Okay, thank you, Laura. We appreciate your report. Okay, customer service division, Jacqueline Rush. I think she's here to give us a report.
Good morning, board members. I'm going to start off with some personnel updates in our division. We've had 2 customer service representatives who've been promoted to CSR 4s, and that means that they'll be assisting with tracking and resolving more complex customer issues, as well as assisting with emails and assisting customers on the phone. We've had we've hired 6 new CESRs, customer service representatives, since December 1st of 2020. These include Spanish, Vietnamese, and Chinese Mandarin speakers, as well as English. 2 of these new 6 SARs are currently in training. CSRs are trained on how to adhere to a preset call workflow. They are trained to use the NICE in-contact phone system to take calls and to update a customer resource management system with call notes in order to track customer issues and reduce customer effort in future calls. They're also trained to disposition and tag the calls when they're finished, and the result of that is the report that you'll see here in a second. That's how we count the amount of calls and emails that we receive. They are also trained to send email templates when needed to help shorten call times and keep the information consistent and explain more complicated issues in writing, so that we can make sure that everyone gets the correct information the first time they call. And they are also trained to work with their team lead to escalate more complicated issues that might need some research in order to achieve resolution. CSRs navigate several databases, including some of the ones we've got listed here: Tulip Dashboard, Versa, Access. We've got several databases that they are needing to learn before they can start the job. So that's what our new trainees are experiencing right now, in addition to learning about our 40 programs and hundreds of license types. I do want to mention that since March of 2020, we continue to work from home. Moving on to the statistics, you'll see some interesting fluctuations. The calls remain consistent, not too much of a change over the previous fiscal years. We have done some experimenting with our emails. Starting in March of 2020, we started routing customer emails that would come in with documents directly to the corresponding licensing team to avoid bottlenecks. Because usually when there's paperwork attached, that is something that needed to go to licensing. After reviewing, other emails that came in through different divisions, we started sending more emails in October. So you'll see that for this industry, for towing and storage, all of the emails actually go directly to Laura's team, Ms. Hernandez's team, and licensing. So definitely let me know if you have any questions on that. What kind of calls and emails we receive is usually, something that folks want to know about. Tow and storage customers typically contact us via calls and email to get initial application instructions, laws and rules, when they're setting up a new tow company or a new vehicle facility. So want to make sure that they're set up in the right direction, and will often call us for more information. We do provide assistance in credit card payments for the tow operators. So if a tow operator is needing to renew their license, and they do that online, some folks like to call and actually talk to a person and get help with that, and we're happy to do that. We can also assist in changing contact information, and we can also assist in clarifying renewal information for callers. And that's typically with the industry. And I'll be happy to take any questions.
Any questions from the board? Well, congratulations to the 2 agents that were promoted to CSR4s. That's exciting.
Madam Chair, Mary
Yes, ma'am.
Winston here. How are you?
Great. Good morning, Mary.
I'm good. So we have a visitor here today, and our chairman. I'm
Thank
looking
you so
for his
much. I'll pass that along.
picture again. Chairman Figueroa, there you are. I wanted to acknowledge his presence And so wonderful for him to take time out today to visit with us during our meeting, firsthand seat, and wanted to know if he wanted to make any statements today, and just thank him for coming.
Barry, thank you. I appreciate it. I'm here to listen. I'm here to see how I can help you guys in any way possible. I can't stay for the whole meeting, but I'll definitely want to hear, how you guys are doing. And if there's anything I can help you with, you have my ears and my full attention right now. So thank y'all.
Well, welcome. We're glad you're here today. We appreciate you giving us some attention and taking us as a priority. Okay, so that moves us on to the Enforcement Division.
6.
Good morning,
Amy, I've got a
Presiding
question on
Officer
statistics.
Milstead.
I think we have two folks speaking. Was that you, Ken Ulmer?
I just had a quick question on statistics, and maybe it was answered. I didn't hear it. I know, unfortunately, I couldn't get my unmute to push, but I noticed we went way down in emails. Did I miss the answer for that? Why we went down to such a low number in emails for TOW VSF customer service contacts?
Hi, this is Jacqueline. Yeah, what I had mentioned, and I know I probably spoke really quickly, starting in March of 2020, we started directing emails that came in with documents directly to the licensing division. What we found is a lot of those documents needed to be processed by licensing, so we wanted to make sure that we weren't creating a bottleneck. In evaluating the rest of the emails throughout the rest of the months, a lot of those emails appeared to need to have gone to certain licensing teams, including the tools team that processes licenses for towing and vehicle storage facility. So October of 2020 is when we started forwarding all the emails for that industry directly to licensing. So those have been routed. And so we're kind of studying it, team industry by industry, to see, where we can actually help in customer service and where we are becoming a bottleneck. And so we're experimenting with that with the hope of just keeping the wait time for a response down.
Okay. So the few that were left, the 3, the 4, and the 3, were those ones you could help?
No, so those show up sort of in a different way. We did have industry emails that were sort of old school emails that are still out there, and so those were showing up for us. And anything that we could answer, we would answer, and anything as usual that would need to go to a different division, we transferred there.
Okay, gotcha. Thanks.
You're very welcome.
And Board Member Ulmer, this is Laura Hernandez with licensing, and I just want to say, and we are working on getting those statistics since they were moved over to licensing. Unfortunately, right now it's a manual process for us for all the emails from the different programs that the team handles, and so that is right now is so that we can provide those numbers to you now that they come directly to the team.
Great, thank you.
We will be providing that.
Any more questions from the board? Sorry about that, Ken. Didn't mean to skip over you.
No, it's okay.
Okay, Enforcement Division, I think is where we left off. Jamie, are you with us?
Yes, I am. Can you hear me?
Yes, sir.
Hey, good morning, Presiding Officer Milstead and board members. My name is Jaime Uribia. I'm a prosecutor with the Enforcement Division, and I will be presenting the division's staff report. First, we have personnel updates. On November 6, 2020, Prosecutor Ken Sharp retired after 7 years of service with TDLR and 13 years of total service to the citizens of Texas. Ken worked briefly on the transportation team before joining the criminal history review team. Ken evaluated thousands of applications to see whether the applicant's criminal records were serious enough to prevent them from being licensed. Ken was very active in the department's Veterans Association. He was both a co-founder and its first commander. On December 4th, 2020, Prosecutor Michael Shirk retired after 8 years of service with TDLR and nearly 2 decades of service to the citizens of Texas. Michael was a member of the transportation team, where his enthusiasm for public service and protecting the citizens of Texas was clearly evident. He was a pleasure to work with, and he served as a mentor for many of our staff attorneys. Michael will be missed, but his legacy of public service will long be remembered. 3 attorneys, Amanda Barrera, Arusa Nizami, and Natalie Olvera, were promoted to Attorney 3 positions to fill the vacancies that were created by the promotions and retirements within the Enforcement Division. Amanda's and Arusa's promotions were effective December 15th, 2020, and Natalie's promotion was effective on January 1st, 2021. Finally, on January 4th, 2021, Arthur Arevalo was hired to fill the investigations manager's position. Art retired from the Austin Police Department after nearly 26 years of service. He worked for the Travis County Sheriff's Office and more recently served as a captain with the Texas State University Police Department. We look forward to Art's contribution to the success of our team as the department continues to strengthen the Enforcement Division with staff that embraces our mission and shares our dedication to making a positive impact while serving the citizens of Texas. Next, we have the statistics for fiscal year 2021, which includes the period of September 1st, 2020 through January 31st of 2021. Now, we have closed 396 cases of the 509 cases that were opened in tow, and we have closed 181 cases of the 226 cases that were open in the VSF program. This is understandable since we are receiving complaints on a daily basis, and it takes time to close cases. Now, the average time to close cases is a little high in both the tow and VSF programs, 281 and 290 days respectively, and we're working to reduce these averages. I am confident that you will see these averages come down during the rest of the fiscal year. Prosecutors Arusa Nizami and Natalie Olvera have joined the transportation team, and they will help us lower these averages. I apologize, but I'm hearing a lot of background noise. Can you still hear me?
Yes.
Okay, thank you. Now, the percentage of cases resulting in disciplinary action is 9.34% for tow and 18.23% for VSF. These are low numbers, and what these numbers show is that the department really works with the industry to assist and gain compliance to the laws and rules governing your industry. There are a lot of laws, a lot of rules, and the department's philosophy has always been to vigorously protect consumers and the Texas public. Having said that, we view industry members as allies, and yes, while we do regulate your industry, you are our customers and we want you to succeed. We are here as a resource for your industry. Now, cases pending at the end of January, there were 937 for tow and 464 for the VSF. And on the TDLR column, that's the number of cases for all of TDLR as a whole. Now let's look at the source of cases open through fiscal year 2021. We'll go down to case outcomes. Now we have commission orders, and we have 5 in tow and 1 in VSF and 19 in TDLR as a whole. And a commission order comes after an administrative hearing before an administrative law judge, an ALJ. This ALJ issues a proposal for decision, a PFD, and an ALJ cannot issue a ruling, so the PFD is not a final decision in the case. The final decision is made by the Commission of Licensing and Regulation, and the Commission can either accept, reject, or modify the PFD. After the Commission makes a final decision in the case, a final Commission order is issued to the parties. Now, default orders, there are 19 in tow and 7 in VSF. And once our charging document, the Notice of Alleged Violation, or the NOAV, is sent, we allow time for the respondent to contact us, If the respondent does not contact us as instructed in the NOAV, we send a notice of default letter advising the respondent that the department will be proceeding with a default judgment if we don't hear from them. If we still don't hear from the respondent, we proceed with a default order. And the department is very diligent in ensuring that the respondent has received notice during every step of the default process. We do the same thing through every step of the NOAV process. A default order is then forwarded to the executive director for signature, and it takes effect once he signs that default order. Now, in agreed orders, in tow, we have 28. In VSF, we have 30. When the department settles a case, we proceed with an agreed order. And a agreed order is simply a settlement agreement which lays out the law and or rule the respondent violated and the amount of the administrative penalty and or the sanction on the license. And an administrative penalty is a monetary fine paid directly to the state, and a sanction is an action upon a respondent's license, which may include suspension, a probated suspension, probation terms, probated revocation, all the way up to the most serious thing is the revocation of the license. Now, the agreed order also lists the payment terms of the administrative penalty. This agreed order is also forwarded to the executive director for signature, and it also takes effect once the executive director signs the agreed order. Now, penalties assessed and penalties collected. The department has been assessing penalties, but the collection is low, around 30% for the tow program and about 40% for the VSF program. This may be as a result of the economic times we're going through due to the pandemic. The department may refer cases to the Office of the Attorney General for collection activity, and the department has another tool for collection of penalties. For example, we may not renew a license until the administrative penalties are paid. Now, licenses revoked, disciplinary. There are 8 in tow and 5 in the VSF program. And like I said earlier, this is the most severe punishment one we can give to an individual, and it's the revocation of the license. The department regulates thousands of tow licensees and thousands of VSF licensees, and 13 licenses revoked, even though it sounds a lot, but in the big picture, it in comparison to the overall licensee population, it's not that many. And if the next is licenses suspended, there's only 1 in the tow field program, excuse me. Next, we have licenses denied, revoked, criminal history. We have 9 in tow and 2 in VSF. Now, criminal history complaints arise from criminal background checks on license applicants. We have specific parameters for each license in terms of what could disqualify an applicant from holding a license. The criminal convictions guideline sets out the specific criminal convictions. They may render an applicant unsuitable for a tow or VSF license. And it also lists the reasons why those particular crimes are considered to relate to the tow or VSF license that the individual is trying to obtain. Next, we have cease and desist orders. As you can see, there are none in tow and none in the VSF. And these are rare orders that are issued by the executive director for unlicensed activity. This order prohibits the respondent from continuing to engage in the unlicensed activity. And the strength of the cease and desist order is that it's the first step towards getting the Attorney General's office to issue an injunction and possibly holding a company or an individual in contempt if they continue with the prohibited conduct. Now, next is informally resolved. Informally resolved, we have 342 cases in tow and 142 cases in VSF. Board members, Ms. Mora and Mr. Ulmer had requested additional statistics that breaks down the informally resolved cases. Specifically, Ms. Mora had requested more information regarding informally resolved cases, and more specifically, cases closed for insufficient evidence. Mr. Ulmer at the last board meeting stated that he, as the industry representative, is frequently approached by industry members who express concerns that they are penalized more than other industries. So I want to address some of those concerns. We will have these performance measures, and I commit to this, that we'll have them at the next enforcement staff report for your next board meeting. So we'll include this in the next staff report. However, I can give you some information today. I can give you information regarding informally resolved breakdown, and I will give you the number of cases closed for insufficient evidence in tow, VSF, and TDLR as a whole. Plus, I will give you the percentage breakdown of the cases closed for insufficient evidence in relation to the total cases closed for tow, VSF, and TDLR as a whole. So of the 396 cases closed in the tow program, 174 cases were closed for insufficient evidence. So of the 181 cases closed in the VSF program, 72 cases have been closed for insufficient evidence. Of the 4,127 cases closed in the other TDLR programs, 1,172 cases were closed for insufficient evidence. Now, let me give you the percentages. In the tow program, 43.9% of the 396 cases closed were closed for insufficient evidence. In the VSF program, 39.8% of the 181 cases closed were closed for insufficient evidence. In the in TDLR programs as a whole, 28.4% of the 4,127 cases closed were closed for insufficient evidence. As you can see, in the tow program and the VSF program, that's a significant amount of cases which were closed, that they were closed because of insufficient evidence. 44% in tow and just under 40% in VSF. And in TDLR as a whole, just under 30%. That's significantly more cases closed in tow and VSF for insufficient evidence. At the next hearing, we will have more statistics with further breakdowns. We're going to address, for example, warning letters, complaints withdrawn, informally resolved. Yes, there's another subset entitled informally resolved under informally resolved. And there's another section called other, which deals with, when businesses are closed or they're referred to other agencies. But we'll get those percentages and the amounts in the statistical report for the next board meeting. And since we did talk about insufficient evidence, I just want to tell you what happens. When we look at a case and determine that there is insufficient evidence to prove a violation, well, once we look at everything, we will send a closing letter telling the respondent that we did not find sufficient evidence to prove that a violation had occurred. And if there is a known complainant, we also send a copy of the closing letter to the complainant so he or she can understand why we closed the case. And I said known complainant because a lot of times cases are opened by anonymous complainants. So now I'm going to move on to the top tow violations for fiscal year 2021. That's through January 31st of this year. The first one is without authority of without authority or illegal tow, 190 cases. This is usually our number one violation. It's by far the largest number of the tow violation. And the law provides very specific reasons for which a vehicle may be towed. And if a tow occurs without that legal authority, then it is an illegal tow. And the department views the towing of a vehicle without authority or an illegal tow as a very serious violation, and we prosecute these cases. The next is criminal history, 118 cases. These cases involve a licensed applicant who has, a criminal conviction or a deferred adjudication or somehow misrepresents. They basically are not truthful regarding their past criminal history on the licensing application. The next one we have is charged more than allowed for tow, and there's been 47 cases. This violation occurs when, a municipality has a limit on the tow fees that can be charged for an incident management tow, and tow companies ignore these caps. The next one is tow without proper signage. There were 29 cases. And the department wants to ensure that the required notice is given to the Texas public that their vehicle may be towed. So this violation occurs when the required notice is not given because a proper sign required by the statute is missing. And the same statute also includes details of what the sign should look like, the size, color, and the height. And the bottom of the sign cannot be lower than 5 feet, no higher than 8 feet. Would we issue an NOAB because the bottom of the sign is 4.5 feet high? Probably not. Or rather, what we look at is whether the vehicle owner had reasonable notice that their vehicle would have been towed once they enter the parking facility. Now, the next one is lacks honesty, trustworthiness, or integrity, and there are 24 cases. And this is a serious violation. The majority of the time, this violation occurs because of flipping, which is a big problem in Montgomery and Harris counties. A small number of tow operators use dishonest conduct to fraudulently induce a vehicle owner to authorize the tow of the vehicle to an unregulated body shop where fees are not regulated by the department, instead of towing the vehicle to a licensed vehicle storage facility where the fees are regulated. And once the vehicle arrives at the unregulated body shop, the consumer is automatically charged thousands of dollars in fraudulent fees. Examples of these are admin fees, the document fees, safekeeping fees, hazardous material fee, preservation fee. And flipping cases involve vehicles which are, a total loss and have no business being flipped or taken to an unregulated body shop because they're not going to be repaired. The next is did not tow in safe or competent manner, and there have been 11 cases. Now, we recently had a case where a vehicle had fallen off the back of a flatbed tow truck, and we've had vehicles that have been towed while people are still inside the towed vehicle. What we look for is we look for negligence or reckless conduct in these types of cases. This is a major public safety concern, and we will prosecute these types of cases. Next, I'll talk about the 11 expired tow company licenses versus the 9 no tow company license violations. The former is a Class B violation, and the latter is a Class C violation. In the former, the company has 6 months to renew the license, and if it fails to do so, it becomes the latter, a no tow company license violation. And the penalty matrix allows for a maximum $1,500 administrative penalty for a Class B violation, and allows for a maximum of $4,000 administrative penalty for a Class C violation. If the tow company continues to perform towing operations when the tow company is expired, the department, can seek a cease and desist order. And we also take these violations very seriously, and we will prosecute unlicensed tow companies. The next one is fail to have proper information on a ticket. There's been 10 cases. Some of the common violations are failing to list the name and TDLR number of the tow operator on the tow ticket, or failing to list, where the vehicle was towed from, where the vehicle was towed to, or the required vehicle identification information. Now, the next one is fail to issue a tow ticket. 9. We see this violation where the vehicle owner who is at the scene of a traffic accident is not given a tow ticket during an incident management tow. And this happens more when a flipping scheme is being conducted and the tow operator intentionally fails to issue a ticket, or even give a ticket because it could potentially be used as evidence against the tow operator. And you can imagine how many tows have been performed during these last 5 months of the fiscal year. 9 violations are not that many, so 9 violations for failing to issue a tow ticket is not a big problem. Okay, now there's tow violations resulting in disciplinary action through January fiscal year 2021. I'm not going to go through all of them, but I am available at the end of my presentation to answer any of your questions. So we'll skip down to the top 10 BSF alleged violations at opening through January of fiscal year 2021. I'm just going to touch on a few of these. And again, I'll be happy to answer any questions at the end of my presentation. Let's talk about the first one, fail to timely send or publish notice. We do consider these violations important when there's actually consumer harm. For example, when somebody had to pay additional monies because the first notification letter was not mailed timely, we view that as serious. And another example would be when the vehicle owner loses a vehicle because they did not receive the second notification letter. Serious violation. We do prosecute these cases. Charged impound without services or dates. This occurs when a BSF charges an impound fee, but the rule requires that the BSF lists the date the service was performed and also what service was performed to earn that fee. And let's talk about fail to release with vehicle with proper documents and fee. This usually occurs when the BSF employee is presented with a document that he or she is not used to seeing when somebody stops by to seek the release of a vehicle. We always work with the BSF to ensure that they understand what documents can be presented for the release of a vehicle. And that's mostly that we use that to train or to teach the employee what is required, because they're so used to seeing one particular document and they see another of the many documents that can be presented, and we teach them, and that way it won't happen again. The last one I think I'll talk about is overcharge for daily storage. There's been 13 cases. If the vehicle is under 25 feet or less, there's a maximum daily storage fee of $20. And the vehicle is more than 25 feet in length, the maximum is $35. And if they deviate from that, and there's no, if they deviate from that, there is a violation. Next, we'll go to the top BSF violation resulting in disciplinary action through January of fiscal year 2021. I believe it's about 15 or 16 of them. I'm not going to go through all of them. I'll just point out that the number one is failed to include required information on notice. And if you have any questions regarding any of these violations, I'll be happy to answer your questions at the end of my presentation. And let's go down to statistics for fiscal year 2020, which ran from September 1st, 2019 through August 31st, 2020. I'm not going to go through these statistics in great detail. However, I do want to address the concerns that were expressed by board members, Ms. Mora and Mr. Ulmer at the last board meeting in November. We'll just go down to performance measures. Again, real quickly, cases open 11:59, cases closed 10:35. And if you notice the average time to close, it's a little lower here. It's just under 200 days. Same percentages of cases resulting in disciplinary action. We'll continue scrolling down into case outcomes. And we'll go to where it says informally resolved at the last performance measure. And I'll break this down. In informally resolved, there were 513 cases out of the 1,035 cases closed in the tow field, in the tow program, that were closed because of insufficient evidence. And in the VSF, it was 192 cases were closed for insufficient evidence of the total 500 and I'm sorry, I said that incorrectly. Yeah, no, I said that correctly. I'm sorry. I'll repeat that. There were 192 cases closed for insufficient evidence of the total 565 cases closed in the VSF program. And the percentage breaks down this way. 49.6%. That's 49.6%, nearly half of all the cases closed for tow were closed for insufficient evidence. For VSF, 34% of the cases closed in the VSF program were closed because of insufficient evidence. Those are high numbers, high percentages. Now, TDLR as a whole, 26.4% of the cases that were closed because of insufficient evidence. And again, at the next board meeting, we will have these statistics in the enforcement staff report, and we will also have statistics regarding warning letters, complaints withdrawn, informally resolved, and other. Okay, let's go down to top 10 tow alleged violations. I'm not going to go through all these. Just want to point out that without authority or legal tow is the number one with 380 cases. And then we have the tow violations resulting in disciplinary action for fiscal year 2020. And then we have the top 10 VSF alleged violations at opening for fiscal year 2020. And then we have the top 10 VSF violations resulting in disciplinary action for fiscal year 2020. And next we'll proceed to the case highlights. The first one is Ostex Towing and Recovery, LLC. And on November 12, 2020, the executive director issued his agreed order assessing respondent an administrative penalty in the amount of $24,000, $8,000 for each of the 3 listed cases. In each of the cases, the respondent failed to conduct vehicle storage facility operations with honesty, trustworthiness, and integrity, which are Class D violations. Respondent in each of the 3 cases also intentionally failed to remit proceeds in excess of actual fees and charges to the person entitled to those proceeds, which are also Class D violations. For example, on February 5th, 2019, the respondent accepted a 2010 Toyota Tundra for storage at its 40 Drive, Austin, Texas location from a non-consent tow. The respondent sold the vehicle and obtained $8,000 in proceeds. Respondent was entitled by law to retain the proceeds, the amounts that were actually incurred for the tow and the storage of the vehicle, and was obligated by contract to remit 20% of the gross proceeds to the city of Austin. The respondent made a knowingly false report to the city of Austin that it had only obtained $800 from the sale of this vehicle. Thus, respondent intentionally failed to remit proceeds in excess of actual fees and charges to the person, the city, entitled to those proceeds. The administrative penalty has been paid in full. The next case is Gareth Francis. On September 29th, 2020, the Texas Commission of Licensing and Regulation adopted a proposal for decision issued on June 11th, 2020 by Administrative Law Judge Shannon Salcedo with the State Office of Administrative Hearings, recommending the revocation of respondent's license and assessment of an administrative penalty in the amount of $11,500. Respondent is a sole proprietorship doing business as Lightning Towing and Recovering and is licensed by the department as a tow company. ENN Collision Center is an unregulated body shop owned by the respondent, which is located on the same property as respondent's regulated towing company. In both cases, the tow operators working for the respondent used deception to induce the vehicle owners into transferring their vehicles to an unregulated body shop and thus failed to conduct towing operations with honesty, trustworthiness, and integrity, which are Class D violations. In the latter case, the tow truck driver failed to prepare and issue a tow ticket for the non-consent tow, which is a Class B violation. On February 3rd, 2021, a second demand letter for payment was mailed to respondent, and respondent has not made a payment to date. The next case is Matthew Gonzalez. On September 15, 2020, the executive director issued his default order assessing respondent an administrative penalty in the amount of $3,000. On January 1st, 2019, respondent operated a towing company without an appropriate license, a Class C violation, and performed a private property tow while not insured against liability for property damage incurred during towing operations, a Class D violation. On November 13, 2020, a second demand letter for payment was mailed to respondent. Respondent has not made a payment to date. The next case is James M. Winkler. On September 25th, 2020, the executive director issued his agreed order assessing respondent an administrative penalty in the amount of $4,050. On November 16th, 2019, respondent operated an uninsured and unlicensed vehicle storage facility, both Class D violations. Respondent has made 3 payments totaling $1,050. However, respondent is past due in the amount of $2,100. He has failed to make his $350 monthly payments from the period of September 2020 through February of 2021. And the last case is the case of Lee Calloway. On October 19, 2020, the executive director issued his agreed order assessing respondent in an administrative penalty in the amount of $1,200. On January 30th, 2019, respondent failed to send the required initial notice within 5 days to the owners and/or lien holders of a vehicle stored at his vehicle storage facility, a Class B violation. Respondent also charged a notification fee before the first notification letter was sent, a Class B violation. The administrative penalty has been paid in full. That concludes my presentation. I'm happy to answer any of your questions. So, does anybody have any questions?
I don't have a question, but I would like to commend you for putting the information together that myself and another member requested. And I really appreciate the fact that you went in depth on that and that we're even going to get more in depth on it. So I thank you very much for doing that. I think it definitely shows exactly one of my concerns, which is that the towing and VSF operations do get a lot of scrutiny from consumers that in many cases are unwarranted. So that's one of the key things that I wanted to bring to light. And I really appreciate you putting in all that effort. Thank you.
Mr. Ulmer, I just
Yes,
wanted to say that I want to give a shout out to Griselda Perez, our management analyst, who put this all together for us. And we are going to be providing more additional information at the next board meeting. And thank you.
I very much so appreciate you being so responsible and bringing that stuff forward. Thank you.
I would also like to add that I thank you. This was great information, very detailed, and thank you to Ms. Perez on the back end for putting this together as well. It's just really important for us to be able to see, have this performance measures in detail and very transparent and understandable, so that we can have a really good idea of how our industry is doing. But also, these measures speak volumes, so I want to really also join Ken in saying thank you so much for bringing this in such detail and presenting it. The one question I do have has to do with, it's on page 2 of 9, under the case outcomes. So I see that there's fees assessed and there's penalties collected. And my question is, the fees assessed that are reflected, I know in some cases, some licensees are assessed a fee, but then perhaps there is a reduced penalty that's assessed. So my question is, the fees assessed that's reflected, is that the original penalty or have to reduce penalty?
I believe it's actually the reduced penalty, because when we seek to collect a penalty, it's something that we've already asked for. And if, for example, there's a notice of alleged violation and we ask for a certain fee, we can negotiate that down. But if we have an agreement, then there's a set fee. We can negotiate that initial structure fee in the notice of alleged violation, if that makes sense, or did I explain that correct?
Yes,
And
that
then,
does make sense.
and
That
then
helps.
once we, for example, we have a respondent and we agree to terms and we seek to collect those penalties, we seek to collect what we had agreed upon. And then we list of what we have collected from that agreed upon settlement.
Understood. Thank you. I appreciate that clarification. And I also, I in the reports and also by the cases that are there, that there seems to be some some collection efforts and such for the unlicensed, those who are working with no licenses in the state. And I know that was a concern with the industry. Is it seemed like those who are licensed are the ones that can be penalized and fined, but those that are operating perhaps with no licenses and such, there was a great concern as to how successful are the efforts of TIPLAR and pursuing those without licenses and being able to collect and find them accountable. So thank you for some of that information as well.
Yes, I also wanted to say that regarding fees collected, we have, like I said, we have the Attorney General that helps in collections, and we also have, we can use collection agencies to try to recover those monies. And I just got a little message. I just wanted to point out that some fees are collected are lower because some respondents are on payment plans, so we haven't collected all the fees. So that's why some of the fees can be, they're still on a payment plan, so we haven't obviously collected those fees. We're in the process of collecting those fees on a monthly basis. So relating back to the first question.
Thank you.
Okay, board members, are there more questions out there? Okay, Jaime, I have a question. On page 6 of your report, alleged violations for the top 10
Sure.
alleged violations at opening. Criminal history is the second one on the list, 285 to count. What kind of criminal history are we talking about?
Well, what first happens is when a person wants to get a license or they want to renew a license, they have to fill out an application. So then it goes to the licensing division. So the licensing division runs a check on the history. They do a DPS search. And once that is done, if there's a violation there that may make someone unsuitable for obtaining a license, it then is forwarded to the enforcement division. And the enforcement division, we have 2 prosecutors who handle these types of cases. Now, in the tow and the VSF cases, we look at what, we have guidelines that tells us what parameters, what violations affect a license. For example, a tow operator. He's obviously going to be driving his tow truck on the highway, the roadway. So we look at whether or not, we look at alcohol-related offenses and things like that. So it has to be related to the offense. Obviously, they're working with vehicles, property, and a vehicle can sometimes be one of the most expensive things a person can own. So if they have theft-related offenses in their background, we look at those type of things. So it runs the gamut, but we have the guidelines that focus on the specific job of a tow operator, tow company. Same with the VSF employee, VSF company. And we see how that relates to the specific licensee, a license that the person is trying to get. And that's what we're looking at. So each program that we regulate is different. So did I answer that? So it runs a gamut. There could be many. There are some cases where if you've been in a state prison, if you went to prison, you can't get a license. So it depends on. It can depend. There's many different. I'm hearing. Can you hear me? Because I'm hearing a lot of background noise.
Yes, sir. Yes, sir. Okay. All right. Thank you. Thank you for that clarification. Tasha and Ken made some very valid points. I think, again, the more information we can get and the more detailed and drilled down into this, it helps educate our industry. And I think that's what we're here for. We're trying to teach them where the mistakes are being made so that they will be more cautious and aware of the problems and the things that are happening. I want to let the guys know we're definitely going to miss the prosecutors who retired. They were a tremendous help and we worked very closely with them. They'll be missed. We know this. But also congratulations to the 3 attorneys that are going to step up and fill some of those positions. I know we all look forward to working with them and hoping we can learn something from them as well. And then welcome to Arthur Aravelo. I hope I said that right. We're glad to have him and hope we can build a rapport there. Thank you. Thank you so much, Jaime, for your report.
Well, thank you.
Okay, Field Inspections Division. I believe Ron is here to give us a report on that.
Sorry. Good morning, board members. I double click in the start video. My name is Ron Gerke. I'm with Field Inspections. I'm the North Region Manager. I'm glad to be here today to give this presentation. I'd like to go over a couple of personnel updates that we have in Field Inspections. First of all, welcome and congratulations to Mr. Eric, Beverly, who is the new Director of Field Inspections. Eric comes from TDLR's Office of Strategic Communication, where he served as Senior Government Relations Officer. And he came to Field Inspections effective February 1 of this year. So again, welcome to Eric. We had a couple of our liaisons depart in February, and that being Angela Sanders and Sean O'Neill. They both moved to the Regulatory Program Management, RPM, as on their health professionals team. So we wish them success in TDLR and their new positions. Next,
Ron, before we go on to the statistics, we have Eric Beverly here. Eric, would you like to introduce yourself?
Good morning, everyone. My name is Eric Beverly. It's wonderful to be here with you today, and I look forward to working with y'all in my new role. Please let me know if I can ever be of assistance to you. Thanks so much.
Okay, thank you, Anna and Eric. Okay, thank you, Anna and Eric. If we can move to the statistics, please. If you'll note at the difference, Field Inspections ceased conducting inspections in March of 2020 due to COVID. And we did start those up again later on in the year. There were some variables. You can see we were doing quite well in the first and second quarters of 2020. And we have picked up a little bit in the first 2 quarters of calendar year 2021. If you note down in March of in the third quarter, we had done 62 before COVID hit. And you'll see the 2 that are in April and the 5 that are in May. In order to continue to conduct field inspections, we started field testing virtual inspections. And that's what those numbers do reflect. Contacting VSFs and conducting virtual inspections, of which in June we circled the wagons and did a review of the process from inspectors and management to how to provide better service to our Texas citizens. And in July, that number pretty much reflects 100% virtual inspections across TDLR. And then in August, we were able to do some limited on-site inspections. And please note that there were many counties that were closed in Texas due to COVID that we could not go into physically. And those affected areas such as Houston and Dallas-Fort Worth, where a large number of BSF facilities are located. Virtual inspections helped us a little bit. And then we also had a decrease in travel budget, which limited our abilities to get out into the field. Some of the most common violations, you can see the impoundment fee was our number 1, and that was for charging more than $20. We had 19 of those violations. I hear some feedback. That's not for me. Yeah, just saying. And notice of complaints was number 2. I'm not going to go through all of these, but that had 18. And that was failure to notify the vehicle owner. Notice of violations, we had 17 of those, and this is for the first quarter 2021, by the way. I apologize for not mentioning that. Reasonable storage efforts, that was 11 for storage of a vehicle, not securing it properly. And then our final one, number 10, was lot surface improper type, and that we had 9 of those. Juan Munoz, our Central Region Manager, and Colleen Cloudy, our lead facilitator, have both been working with TDLR and the new licensing system, or TLS. We hope to have on board sometime in the near future with TDLR. That concludes my presentation. If anyone has any questions, either Eric or myself would be glad to help you out.
Board, any questions for Ron?
Yeah, Ron, this is the board member Jimmy Zelke. Can you elaborate on what is a virtual inspection? What's required?
Very good question, sir. Yes, we actually we call the owner and we see if they are, first of all, we determine their eligibility. Some people may not be eligible, and we're literally calling through FaceTime or Google Duo, some type of a platform with the representative through our telephone instead of showing up on the site. It's a virtual inspection through media on a platform. And a lot of people appreciated that, especially with the COVID situation. So we're conducting the inspection, except not showing up, we're doing it through media. Did that answer your question, sir?
Yes, sir. Thank you very much.
You're very welcome.
Any other questions? Okay, that moves us along to Regulatory Program Management Division, Todd Forrester.
Good morning. I'm Todd Forrester with the Regulatory Program Management Division. As you can see from our report, we're continuing to keep statistics on the number of contacts that come into the department, as well as keeping tabs on our industry compliance page, which is continuing to see additional traffic to it, which is good. It shows that the industry is wanting and needing a little more information over the laws and rules. For our current projects, we're going to continue to analyze that information, both questions that come in either through the trainings, emails, and phone calls, and the hits on the website, so we can try to determine what information the industry needs and how we can better assist getting them that information. For outreach, we are continuing our Zoom trainings. The Zoom trainings have been successful. We're doing one a month on a regular basis. We also are more than happy to set them up with other companies if they have any questions, or if they have a lot of employees and they just want to go through everything. The industry has been very willing to accept new technologies. This is an industry that works with technologies daily. We've had great success with these trainings over Zoom. It makes it easier for the industry. They don't have to travel. It's easier for us. We don't have to travel, and we can do them a little more frequently. So we're going to keep that up and look to expand a little bit more on that if we can. If anybody would like a training, please let us know. Are there any questions?
No
Okay.
questions, Todd, but I would like to comment that I did attend some of those virtual trainings, and they were very, very good, very informative. You got lots of questions and you were able to answer them, and I really appreciate all that effort that you put into those.
Thank you.
Okay, if there's no more questions, Todd, thank you as always for all your hard work and keeping us in compliance with everything and up to speed. Thank you. All right, that's gonna be Education and Examination Division. I believe Michael Strawn is here to give his report.
Yes, ma'am. Good morning, Chair and members. My name is Michael Strawn. I'm manager for Education and Examination Division, and we'll be giving our report today. So as you'll see, for December and January of 21, we had a total of nine different courses that were approved at this time. January had 8. That is in line with other years that we've seen in the past, where January through April tends to be a little bit higher volume for us on receiving new courses. If you go down to our training program curriculums, you'll see that we actually have one more. There's a slight error where there should be a 1 notated for a new curriculum that we received in October for Rec Masters. So we've had 7 courses for a very long time in that, and we now have an 8th one that just came on board. We are getting that corrected, and we're having that sent out to you all here shortly, so I apologize for that. If we go down just a little bit further. And then we have our CE monthly invoices. We sent out 24 in December, And we have $3,750 worth of collection fees left to be collected at this point in time. With that being said, that concludes our report for your industry, and I'm open to any questions that you might have.
Any questions from the board? Okay, Michael, thank you for your report. We appreciate it.
Thank you.
All right, let's move on to Miss Mary Winston with the Executive Office Report.
Good morning, members and everyone out there watching. This morning for the executive staff report, we're going to be doing a duet or tag team with Deputy Executive Director David Gonzalez, who's going to start us off and talk about COVID-19 response update.
Good morning, Presiding Officer Milstead, Advisory Board members, Deputy Executive Director of License Services, David Gonzalez, assisting Ms. Winston. Our illustrious leader, Mr. Francis, is at the Capitol making himself available for committee hearings. And definitely want to give a nod to Chairman Figueroa for being here and making the time for us as well. You may recall that we've updated you typically with our external and internal responses regarding COVID-19. So I'm going to provide you with that COVID-19 update in the same fashion. Externally, the most important thing that we can share with you is the reminder that the latest and greatest information regarding COVID-19 is actually on our website on the very front page. Anything that affects our agency, our licensees, we try to post up there. We are still serving as a conduit of information, things that come from the governor's office, and DSHS, and just a little bit of news that came out. Actually, some big news from the governor's office regarding Executive Order GA34 regarding mask and business capacity. Effective Wednesday, March 10th, there is no longer state-required COVID-19 operating limits for any business, nor are masks required. So take a while to let that sink in. Masks not required, no operating limits for businesses. Now, individuals are strongly encouraged to wear masks, and it's important that everybody know that every business has a personal decision to make, a business decision to make, because they actually may require employees or customers to follow hygiene measures, including wearing masks. So those are things to be aware of. I'm sure it was noted in the news for everybody, but we like to make sure that we say to the public as well. In counties where there's trauma service regions, they're going to be monitoring the hospitalization rates. Our field staff have definitely been doing that, so they can determine whether or not they're going to be doing virtual inspections or in-person inspections. But if hospitalization rates rise above a certain amount, 15% for a certain period of time, counties can actually enact additional requirements. That was the stipulation in the executive order. So also externally, you may recall that because of the COVID affecting us internally, we had some staff actually test positive. We had to quarantine. It created a backlog in our mailroom in our financial services division. An important external effort we initiated to help ease those challenges is emergency rule to allow the extension of emergency licenses. The date actually expired March 15th. It was from August 1st to March 15th. Licensees with dates, licenses issued on or before those dates, on or after the dates of August 1st, 2020 and March 15th, 2021, had their licenses extended 120 days. And that allowed for us to work through our backlog and allow that workload into our licensing division where we can process those licenses. Now we still have a huge amount of work now that it's made it, the watermelon has made its way further through the snake and it's in our licensing division. We have a huge I'm really proud of our staff. We actually asked for assistance from every division of our agency to assist with the licensing process now. So we've got people that were normally working in field inspections when they had a low workload to help us out. We got people working from IT that are helping out with the licensing workload. So it's pretty much all hands on deck. A lot of the people that came from licensing, they already know how to process these. They've already contributed and are contributing to those numbers and improving our turnaround time. For those people that are new to the process, we're working through training and trying to bring them up to speed so that if this ever happens in the future, God forbid we ever have another pandemic, but any other kind of emergency where we have people trained in other divisions that we can bring them in and have them strategically assist us. We're actually calling this the Strategic Workforce Allocation Team. They'd be able to come in and help as necessary to get through any kind of increased workload that may be in our licensing division or our finance division. So those are the things that we've done internally to help with an external problem. Also internally, and it kind of is important to note that we have obligations to keep our staff safe, and the governor's mask directive required us to actually change the signage in our building. We actually took down the signs that said mask required and put up signs that actually stipulated masks are strongly encouraged but not required. And that was from the directive that we actually received from the governor. Our offices are still doing business the way we've been doing businesses. A lot of our staffs are still working from home remotely. For those that can do their jobs remotely, those that cannot, we're still rotating them to try to keep us separate. Obviously, there's light on the horizon with vaccinations, and we're hoping to get as many staff vaccinated, but it's nothing that we can coordinate as an agency. It's individuals and still going by their groups, the 1A, 1B, and 1C groups, and being able to find those appointments, which is very difficult at this time. The customer service lobby at 920 Colorado Street is still closed. We're not accepting visitors. Again, we're still doing our business virtually. Anybody that could or would want to meet with us in person that may drive down, they actually can likely contact us via email and or virtually via Teams. There's ways we can work that as well. So if there's any concerns about meeting with us in person for those people that just like to have a person to talk to, a live person, we may still be able to do it, but it might be virtually. And that's all I was going to report on Sunset, unless there, I'm sorry, on COVID-19 updates, unless there's any questions. Ms. Mary, I'll turn it over to you for the Sunset report.
Thank you, David. I tell you, this unmute button does want to stick today, Mr. Ulmer. I agree with you, just fighting that a little bit. Mary Winston again, TDLR. At our last meeting, we talked about, we went through the Sunset process with Sunset staff. The Sunset staff then made recommendations that were to be considered by the Sunset Commission. Well, we're trucking on down the road. After the Sunset staff made those recommendations to the commission, this is done in a public hearing as well, where the public is allowed to come in and listen, and it's broadcasted, and it's a little different today, or it was, because of what we've all been through, yet we've all persevered and we made it happen, and the commission made it happen. Since that time, the recommendations of the staff were either adopted by the commission or modified by the commission. All of this is available again on our website of those adoptions, or the great thing is that we were recommended to continue for 12 years with adding those recommendations as per the commission. But now those commission recommendations that have gone from staff to commission are now in the form of two bills. We have House Bill 1560 and its companion Senate bill, and the number is not coming to me. Both of those are available on our website for review, and they go through the steps. It's sort of the culmination of steps before a vote is actually taken at the end of this session on what's going to go forth and what's not going to go forth when that bill becomes a law. So with these two companion bills, the Sunset Commission and the Sunset staff has done a job in relation to TDLR. TDLR, as always, tries its best to be an open book and get this accomplished. And whatever, if someone could find the companion Senate bill, I'd like to give it, but I do know it's House Bill 1560, and I will come up with the companion Senate bill. Those things will now be considered during the session to become a law. That's where we stand with Sunset, and more to come, more to come. Whatever's adopted into law in our future meetings, we'll discuss that. Statutes will be here, rules will follow, and that's where we are. If you have any questions, I can provide those answers for you. And if I can't, I will look them up for you. And we're still in transition. This is our session right now going on. The Sunset Bill or bills are part of, oh my gosh, I think it's over 6,000, maybe 7,000 bills that are up for consideration. But our legislature always makes it through them. And during this regular session, this should be considered. Does anyone have any questions about our sunset review update? Okay, David, at this time, I'm gonna pat it back over to him for the 87th legislature session update.
Thank you, Ms. Mary. David Gonzalez, Deputy Executive Director. One point I will remind you about on the sunset bill, because it's probably of most concern to you or most interest to you. Issue 1 included changes to the advisory board and the authority that we have to actually call advisory board meetings. Some of our statutes have statutory stipulations on how many meetings were supposed to be held, and the recommendation from the sunset staff, and it was adopted by the Sunset Commission, is to give that authority to TDLR to call meetings as necessary. So that could affect y'all. Again, that recommendation was adopted, as Mary stated. Now they're in bills, and anything can happen. Once they make it to a bill, language can change, but these are things that we are tracking and are very important to the outcome. And that makes for a nice segue to our legislative session. We started out slow. We had the pandemic going on. People were trying to figure out the leadership, who was going to be in charge, and how they wanted to conduct their business, whether or not to hold in-person sessions or virtual sessions. They've found their way and they've worked through it. In fact, I've been over to the Capitol a couple of times to be tested to make sure that we were going to be okay to get into the building along with my peers. So they've made it. They made us feel safe. They actually made it to where testimony was, whether it was virtual or in person, was very effective. But we thought it was going to be slow and that maybe not as many bills we're going to get through. Turns out that it's been a pretty busy session. And I think the last I recall, one of our staff mentioning there was like 900 and something bills filed on the very last day, which was this past Friday. Last day for filing, or technically was last Friday for filing bills. We are currently tracking around 300 bills that may have some effect on our agency and or our responsibilities. If you want to see which bills those are, you can actually go again to our website, the very first page. There's a link to all the legislation that we're tracking. If you find one that affects our agency that's not on our list, you might give us a call or give us an email, give us a shout out, because we're tracking everything from cannabis bills to sports betting and quite a few tow and VSF bills. I'm looking at a list right now that's got 1, 2, 3, 4, 5, 6, 7, 8, at least 10 bills, and I'm not sure this list from our website is updated with the latest and greatest from this past week. So quite a few bills that could affect the tow industry. Definitely hard to keep up with. Texas Legislature Online, in addition to our website, is what we utilize. But I'd also like to take this time to give a shout out to our government relations staff, because if it was not for them, we would not be able to keep up with everything that's going on during the session. You know, we have our regular business to take care of, our regular jobs and licensing and regulation stuff to do. Keeping up with the legislation is difficult, but with people like Steve Bruno, Eric Beverly, formerly of government relations, now in field inspections, we got some new staff, Jeremiah Kuntz, but the biggest shout out goes to Mr. Jeff Kopus, who actually helps us track the bills. Some general counsel involved in there as well, Jessica Escobar. They're reviewing the bills and making sure that we're staying on top of things that really affect our world. And so we do our best to try and stay on top and be a resource, especially if we get legislative inquiries, but it's difficult. So sometimes the industry and the public is more up to speed on the bills that have just been filed, and we have to try to catch up. Significantly, we've had our House Appropriations and Senate Finance hearings, and that's where Brian Francis actually presented our exceptional items for budget consideration. That's in addition to our regular budget. There's some exceptional items we submitted. The most significant exceptional item that would affect you guys is, or have a positive effect on the tow program, is the one we asked for continued funding for the new Texas licensing system that we're pursuing. We have 8 disparate systems with all the programs we received over the years. We have different databases that we have to do different things with to get our work done, and it's just not effective or efficient. So we're working towards, and have been working towards, a new Texas licensing system, one system that would allow for all of our licenses to be on the same database. We are requesting funding for this next biennium to help support that continued work on that framework and program transfer. And that's all I was going to share, unless there's any particular questions regarding the 87th legislative session. All right, hearing none, I'll turn it back over to Miss Mary.
Thank you so much, David. I think I've gotten a little spoiled because Eric Beverly was formerly in our government relations, and now he's a director. He's going to do a fantastic job there. And we also have Jeff Copus, who has, as long as I've been here, always kept the running track of bills that are that we're watching that relate to our programs here at TDLR. So I got a really quick when I said, cannot remember what that Senate bill number was. I got two answers in the back. It's Senate Bill 714. So thank you, Eric, and thank you, Jeff. Also, Jeff, I'm like, is that website updated? It's probably a rhetorical question. It's updated. There are a couple of things, check later on. He thinks he missed a couple of things and he'll get those updated immediately. Now I want to talk about progress regarding the companion BSF rule to address flipping. As you know, this board has already addressed the tow rule versus concerning flipping. And we do expect this to come into effect or around June. So we're working with session, moving through session, but we're also, Elizabeth is working very hard in the background with everything else going on to get these things going. But since we have the toe flipping rule, that we're hoping is going to be in effect of June 1 for this year, we need a companion VSF flipping rule. That is going to be the first priority that our general counsel's office has informed me, along with, as soon as we get the requirements from the 87th session implemented, that the priority is the VSF flipping rule. So I wanted to take any questions. We have Elizabeth that has popped in, that we can see her now if there are more questions, because this is sort of her wheelhouse and her baby. And this kind of completes my update for that, unless you have questions for me or Elizabeth. Okay, if we don't have any right now, we will move on back. I'll volley back over to David for E.
I like that, David Gonzalez, Deputy Executive Director. I like the tag team work that we're doing here, Mary. It's like a wrestling match. So we wanted to take time on the agenda to give kudos to the many tow companies and drivers for their heroic actions during Snowstorm Uri. You know, Texas doesn't do winter very well. Snow and ice does not do well with the Texas drivers. And I'm sure you probably saw the horrific accidents that were on the freeways and roadways. If y'all were stranded in your house, that was probably the safest place to be. But just wanted to take the time to really appreciate the work that's done when everybody else is staying warm in their home or without water and electricity, but at least safe in their home. There are tow truck drivers out there trying to get clear the freeways and the streetways. And just, I know a lot went into that happening. And during emergencies, the people that step up, the people that really step up for the industry to give their time and efforts, they put themselves in danger as well, and spend the extra time away from their families. So just wanted to recognize the work that was done there, because it is a big deal. When we can't drive in Texas, we love our vehicles. When those roads clogged up, the tow trucks help keep it clear for us and keep it safe. So I just wanted to have that acknowledgement. And lastly, the last tag team was for communication outreach statistics. Mary, you want to take that?
I will take that. And this is a really good example of different personalities. I was thinking more tennis, and David was thinking more wrestling. So that's okay. We're still getting it done. I wanted to highlight on E because our executive director, who, you know, just couldn't be here today because he's busy with session. And we thank him for it. But this was something we wanted to put on the agenda, and his word was heroic. And I think that fits so well with the report that David just gave. Those were scary times. Those were deadly times. And the heroes during that time, we had many, and some of those heroes were our tow truck drivers and our tow owners, and for companies and the things that we talked a lot about essential workers through this year and through this pandemic. And during that time, you all were historic and heroic essential workers. I wanted to make sure we highlighted that. Finally, we have our communication outreach statistics, which is just kind of a snapshot in a 6-month period of the average times that someone reaches out to view our web page. And we have over 305,000 views over this past 6 months, an average of almost 1,700 views per day. 35% of those viewers assessed their site from our site from the desktop computer. 64% did so from a smartphone, 1% from a tablet. That statistic differs depending on which profession we're talking about. So tow, VSF, we know how to work those smartphones. So that is different in other professions where we may find that number flip. Top reasons for visiting the site: to search tow companies and VSFs. Then we have consumer information, how to apply for a tow operator license, vehicle towing and booting law, and finally in that top 5, towing administrative rules. And if there aren't any questions about our executive report today, we will move forward, Madam Chair, with the agenda.
Any questions?
Amy, I just wanted, Amy,
Go ahead.
I just wanted to say thank you to David and Mary for recognizing the tow industry for the help that we give during the storm. I couldn't sleep at night worrying about my guys out there on the freeway, you know, when the weather was so terrible, and we appreciate that.
Thank you. Thank all of you. We do realize that. I have to tell you, we were very blessed personally during the storm, and we were able to just have friends over, and I cooked down a deep freezer. That's what we say at home, because I had extra people in my house who, good friends who didn't have power, who barely were able to inch over. And on the way to my house, there were overturned vehicles, there were people pushing vehicles, and who also was there? Tow truck drivers who were helping those people out. So we really do thank you all for your service.
Thank you, Mary and David. We appreciate that. And thank you for recognizing our industry. We do kind of get forgotten sometimes in the public eye, and to know that we are appreciated and everybody recognizes the work that has to be done no matter what, rain, sleet, snow, and hail, we got to be there. Okay, before I move on, I did forget to welcome Eric Beverly, and I do apologize for that. Field Inspection Director. Eric, welcome. We are so glad to have you, and we look forward to working with you. And then also good luck to Angela and Sean in that department as well as they move on, and good luck in your new endeavors. Okay, that is going to take us to item F on the agenda. Miss Elizabeth Salinas Stripmatter is going to come up and talk to us about the discussion and the possible recommendation to the rule that has everybody talking, the flipping. Elizabeth, I'll turn it over to you.
Thank you, Ms. Milstead. First of all, good morning, everyone. I'm glad to see everyone here this morning. And I echo the sentiments, the kudos that are given to your industry during the storm. Difficult for so many people, including my own family. And so we thank everyone, including your industry, who were the helpers. Mr. Rogers said, look for the helpers, and your industry was part of those helpers, and we appreciate that every day. But I'd also like to welcome our Deputy General Counsel, Ella Lindquist. She's joining us this morning. I don't think the new board members have had a chance to see Ms. Lindquist yet, so she is here this morning to offer moral support as we talk about this flipping rule. And she also wanted to have a chance just to sit in and listen to some of the issues that we're talking about today that have been pervasive issues in the industry. She has been a great resource for me as we've gone through the past month or so, talking about some of the issues that you see on your agenda this morning that we'll be talking about. So thank you for joining us, Della. We all appreciate that.
Thank you.
All right, so without further ado, let's talk about the famous flipping rule. And that, of course, is the moniker that was given to it by Michael Shirk, before he retired the flipping rule, and that is what we continue to call it. But it is absolutely 86.700. That Anna has pulled that up, and I'm going to just quickly go through that rule as it was published. It was published in the Texas Register on December 18th, as you see there at the top, and the deadline for public comment was January 19th. In response to that public comment period, we received 5 comments, which I will talk about here shortly. So as we move through this rule as it was published, if you have any questions or concerns, please feel free to stop me, or of course you can reserve your questions until the end. Underlined text is new language, strike through text is deleted language. So the first thing that we did was that we added a tow truck operator as a person who this is applicable to. 86,700 responsibilities of tow truck permit holders and tow truck operators in the storage of towed vehicles. And we have some new text here in A1 and A2, which states a towing company or tow truck operator that performs an incident management or non-consent tow may only tow the vehicle to one of the following locations. 1, a vehicle storage facility operated by a person who holds a vehicle storage facility license issued by the department, or 2, a location other than a vehicle storage facility licensed by the department that is specifically requested and authorized by the vehicle owner or operator, and to which a towing company or tow truck operator agrees to take the vehicle. All right, and so as you can see then, A1 and 2 with the underlines replaced the strike-through language that exists currently in A. And so what we did was we clarified and broke up, number 1, who A is applicable to, a towing company or a tow truck operator, clarified that it can only be taken to a VSF and or a location authorized and agreed upon by authorized by the vehicle owner, and to which a towing company or tow truck operator agrees to take the vehicle. So in a tow, we all know that there are 2 parties to the tow. It is the tow operator and the consumer or vehicle operator. And so both parties are communicating when those non-consent tows are taking place, and both parties have a place within this rule to discuss and agree upon where it's going to be taken. Now, the purpose of this flipping rule, as we know based on our prior conversation about the rule when it was first presented, is because of the pervasive problem that we're having in a couple of counties with flipping. And flipping, for those who are not familiar with it, is when a vehicle, a non-consent tow, is picked up by a tow operator, and that vehicle is then taken to a non-licensed vehicle storage facility. Typically, it's going to be an auto body shop, and there is typically going to be some fraud in inducing the vehicle owner or operator to turn over that vehicle to a non-licensed entity as opposed to a regulated entity. And so the purpose of this rule is to clarify that the only places that these non-consent tow vehicles can be taken are to a licensed vehicle storage facility or to a location that is requested and authorized by the vehicle owner and to which a tow operator tow company agrees. So what we are doing is we are trying to eliminate the fraud that occurs sometimes when a tow operator picks up a vehicle and the consumer believes that they are signing paperwork that will authorize their vehicle to be taken to a licensed VSF, and instead they're actually signing paperwork that releases their car to a non-licensed entity. And or we are also addressing the problem of tow operators suggesting to a consumer that their car can be taken to a non-licensed entity. And so we see that in B. Anna, if you can scroll up. Neither a towing company nor a tow truck operator may recommend or solicit authorization for a vehicle involved in an incident management or non-consent tow to be towed or moved to any location other than a vehicle storage facility licensed by the department. That gets specifically at the core of the problem that we have seen over the past 2 years. We are getting to these instances where we are seeing non-consent tows bypassing the VSFs and being taken to non-licensed entities, or being taken to a licensed VSF and then having it suggested that the consumer sign release papers to turn those vehicles over to a non-licensed entity. So that is what we're trying to accomplish in B. And then in C, in the event that a vehicle is taken to a location other than a licensed vehicle storage facility, the authorization for the tow ticket must not include authorization for repairs or any other services other than those necessary to perform the tow. So this is where we get to the fraudulent paperwork. This is where we get to consumers becoming really confused, not understanding what they're signing. And so what we are accomplishing in C is saying they will not be signing anything, any authorizations for repair or anything that is outside of what is necessary to perform that tow. So we are trying to bring back the clarification that the only thing those consumers, vehicle owners, operators should be signing is relating to the tow itself. And then we have D, which is a reiteration of what I have talked about earlier. A towing company or tow truck operator may decline to take a vehicle to a location specifically requested or authorized by the vehicle owner or operator. However, if the towing company or tow operator declines, they may not take the vehicle to any location other than a licensed vehicle storage facility as set forth in subsection A1. And the reason why we felt D was important is because, as we discussed at the last meeting, there may be instances where a vehicle owner or operator is involved in an accident 100 miles from home, 200 miles from home, 250 miles from home, and they may actually request that the tow operator take that vehicle 250, 100 miles away. And the tow operator, that may not be realistic. And so we are emphasizing here that they can decline to take a tow to a place requested by a consumer. But if they decline, it can be taken to no place other than a VSF. And we have the language in B that prohibits recommending or soliciting authorization for the vehicle to be taken to any place other than a vehicle storage facility. So this is the rule as it was published. During the last meeting, Mr. Ulmer asked for an and to be placed between B and C. And when we discussed that up in General Counsel, it was felt that the and was implied. And it was also felt that if we put the and there was a great possibility that the Texas Register would actually wind up taking it out. And so we took it back out because it is implied. As I said last time, we read the rule in its totality and its completeness. And so all of these rules go together. You do not see any ors between the sections. And so it's all implied that they all go together, that they work together, all of these new sections. Does anyone have any questions about the rule as it was published before I get to our comments? Okay. Madam Chair, if it's okay, I'll move to the comments. So as I said at the top, we received 5 comments. 2 of those comments, including the first one that you see on your screen, was in support of the rule and said that this is a problem that has been around for a few years. They're glad to see that it's being addressed. The second comment actually did not apply to the rules, and it was a prospective licensee asking for information. We have forwarded that email on to our customer service and to licensing folks. And Laura Hernandez told me yesterday that she actually spoke to that prospective licensee, and he said he has received what he needs. So comment number 3 is also a comment that supports the rule change, and they're glad to see that it's happening. If we can go up to comment number 4, then comment number 4 and number 5 had some criticisms of the rule, and we'll talk about that at the proposed rule, and we'll talk about that in turn. So what comment 4 says is the proposed language allows companies to refuse to tow the vehicles to the destination requested by the owner, which could be 1 mile away, and instead tow it to an approved location, which is typically owned by the tow company and for which extortion takes place at the expense and through no fault of the owner of the vehicle. I understand the point that's being made, but I actually think that this rule, as it has been crafted, specifically is designed to prevent this very scenario. What we have done in allowing the tow truck operators to make the decision of whether or not to agree to take it to the location of the vehicle owner operator's choice or designation is we have built in some protection for them that allows them to decline to have to travel long distances out of their way, or to have to travel to areas that they don't typically travel. But what we have done at the same time is we have said you cannot, number one, recommend or solicit, and even more importantly, the section of the proposed draft rule that prohibits the signing of paperwork that authorizes repairs gets at the very heart of, I think, what this comment is getting to. It gets at the very heart of prevention and protection for the consumer. So by building in these new sections, I think we have actually addressed what this comment is talking about. And we have said protection for the tow operators and tow companies to not have to drive to places that they're not comfortable with or that are completely out of their way. But at the same time, if you're going to take it to some place other than that place requested by the consumer, it can't be a place that you recommended or solicited for, and they will also not be allowed to sign any paperwork for repairs. So you can't hand this consumer some paperwork that then authorizes the transfer of the vehicle to an unregulated entity and then repairs to be started, the tear down of the vehicles that we see happening during these flipping schemes. And so then if we can go up to comment 5, Anna. Comment 5 says, in regards to the proposed amendments explicitly prohibit tow truck companies and tow truck operators from 1, towing vehicles in non-consent tows to locations other than those stated in rule, 2, recommending that vehicles be towed to any location other than a licensed vehicle storage facility, and 3, obtaining authorization from vehicle operators for repairs or any fees other than those required to perform the tow. May I suggest, oh, it just got a little small on me there, Anna. Can you get it back up? Can you magnify it, please?
I'm not sure what happened, but I'm going to go ahead and stop sharing and reshare.
Okay.
How does that look?
That's good. I'm going to just have to look through the bottom of my glasses here for my readers. May I suggest enforcement directly to the, there we go. May I suggest directly to the tow operator as opposed to the tow company? Keeping in mind a tow company owner may not have control of this nor even know that it's happening. Tow companies may get reprimanded as a tow operator can easily move on to another wrecker company with no consequences. Thank you for your time, Shay Adamick. And I apologize if I mispronounced the commenter's name. And so in response to that comment, what I would say is one of the reasons why we have added in the tow companies, and this was talked about extensively at the last meeting, is because what we are getting in enforcement is, I didn't do it, and pointing fingers. And so by bringing in the tow companies, we are forcing, if you will, for lack of a better word, accountability between those tow operators and the tow company. So the tow company is typically coming in and saying, I didn't know, I didn't know, I didn't know. Well, this is behavior that we think you need to be aware of, and you need to be instructing and training your drivers that it should not be occurring, and instructing and training your drivers on what 86-700 says and requires. So respectfully to the commenter, one of the main reasons for this rule proposal is exactly to bring in those tow companies so that we can see accountability on both sides, the tow operators and the tow companies. With that, those are TDLR's responses to the comments. Are there any other comments or concerns before I go into sort of what your options are? Okay, so Madam Chair, where we are at is the board can would like to have this rule adopted as published by the commission during its next upcoming meeting, which is early May. I believe, Della can correct me if I'm wrong, but it's May 5th or May 6th. And we would ask for an effective date on June 1st. Now, we can ask for an effective date on June 15th, I'm told by our rules coordinator, Vanessa Vasquez. But I think that this rule is so important that I'd like to see it become effective as soon as possible, but that is up to the board. So the next step is whether you would like board to send this on for adoption to the commission. If the commission adopts it at its next meeting, we would have an effective date of June 1 and that would be the date that the industry would be expected to comply. We are always, as Todd said during his presentation, RPM is always available to do training. We will probably do some, without speaking out of turn, I think we'll probably do some social media educating on this with our communications folks as well. But this is definitely something that the board has been looking forward to for a long time. And so I think probably June 1 is your better date, but I will leave that up to the board to decide.
Okay, so board members, you heard our options. Do I have a motion to approve and send to the commission?
I make a motion to approve this for adoption June 1st.
Can I get a second?
James
Excuse me,
Spears, seconds.
this is Della. It would actually be adopted in May and effective June 1st.
Okay.
I'll second it, Amy.
Okay, perfect. Okay, so we have a motion and a second. Any more discussion on it? Okay, I think we'll take a roll call to make sure we're all in favor. Anna, you got that?
Thomas Griffin,
Aye.
Jimmy Zulke,
Aye.
Al Jackson,
Aye.
James Spears,
Aye.
Asha Mora,
Aye.
Gary Hoffman, Charles Rath,
Aye.
and Ulmer,
Aye.
and presiding officer Amy Milstead.
Aye.
The motion passes, ma'am.
Perfect. Okay. Next, going to take us to item G, discussion regarding opportunities for improving the world famous VSF 11 form. I know many of you have been on the debate and the side of this, and then we have some new board members that really maybe have not weighed in on this or had any experience with it. So I'm going to start the conversation and then open it up for everybody to discuss. But first, do we want to hear from Mr. Larry Cernasek, his public comment on this?
He is calling in now. He should be in momentarily. Would you like to continue on with your discussion? And I'll let you know. Oh, it looks like he's in now. Mr. Cernasek?
Yes.
This is Anna Clark with TDLR. You're in the meeting with our Towing and Storage Advisory Board. We have 3 minutes for you to give your public comment for item G. You can go ahead and start your 3 minutes. Sir, whenever you're ready.
Okay, so they're taking a vote. They're able to hear us.
So they are going to be taking your public comment for item G, the discussion regarding opportunities for improving the performance of the VSF 11 form.
Okay. First of all, I'd like to thank the chairman, if he's still there, and then the presiding officer and the members and the staff. The VSF 11 form has been a problem for many, many years. And, you know, TDLR requires the owner of a vehicle to prove ownership by a photo ID and other documents. And they require a lien holder to use a specific power of attorney that was authorized by TDLR. And then they also have to have the text dot affidavit for a repossessed motor vehicle and, of course, other documents. So, you know, why should an insurance company be allowed to pick up a vehicle with no proof of anything? The insurance company has no monetary interest in the vehicle until they pay a total loss claim. The owner or the lien holder who has a monetary interest. An insurance company has the owner sign documents before they pay the claim, so why wouldn't the insurance company be required to do the same? The insurance laws give the owner the right to choose the repair shop of their choice, and the insurance company is required to respond to the claim in 15 days. So with technology in place today, the owner can sign to release the vehicle to the insurance company, just like the owner or lien holder has to do. The other thing that's interesting, we just discussed item on the agenda F, and this is the same thing the insurance companies are doing. They're flipping these cars. They're coming with the VSF 11 form. They've never talked to the owner, and then they take them to either Service King or Caliber or one of their approved shops. So it's no different. They are doing the same thing that the towing companies are being accused of doing. So anyway, if we're going to protect the public, everybody needs to sign and have some proof of documentation that the owner or the policyholder has been notified somehow, some way. And, you know, the storage facilities have no problem with the insurance companies coming and looking at the vehicle. The problem is them moving them without the owner knowing, especially when they come 2 days later after they picked it up and the owner wanted to get his stuff out of the car and we don't have it anymore, and we show them the form and they say, well, we never talked to anybody. I know Brian Francis has said that there has been no complaints from the consumer, but the consumer doesn't care about that. They just want their car repaired or totaled and be paid. They don't have time to be filing complaints with TDLR over something that really they don't even know anything about or know what happens. So again, TDLR needs to protect the public and stop the insurance companies, for a better term, stealing people's cars without their knowledge. And I thank y'all.
Mary Winston here. Thank you, Mr. Cernasek. At this time, Madam Chair, we've had our public commenter, and if there's additional discussion that the board would like to have, it would be appropriate now, with the knowledge that we cannot ask Mr. Cernasek any questions. His comment is simply, and we appreciate that because it's his public comment and it's giving us a perspective that the board can consider, but we cannot ask him for any additional comments or can't ask any questions based on his public comment because it's not a part of the agenda to have that question and answer session. So.
Okay, yes, ma'am, I hear you. Mr. Cernasek, thank you for your comments. We appreciate you attending today and your input. Board members, I put this on the agenda because we're still getting complaints from the industry. So it was added, and I'm going to open up the conversation, and hopefully you guys might have something to add. You all got public comments that were sent in. There's a couple that were sent in that we're not here to talk in person or via communications here. So we got diverse opinions. We got some from individual companies. We got some from insurance. And I really hope you guys have read all that. Just a little history on this for the new members. This form was created over a decade ago. This form was created by our past legal counsel, Charles Johnson. And the form was actually designed for owners or family members to pick up their vehicle. Example, someone's in the hospital, they can't come get their vehicle, but a family member wants to come and pick it up or get belongings out of it. This VSF 11 was created just for that, to protect the citizens and give family members a right to get the vehicle. It's been suggested numerous times that we have more information on this form. I know over the years it's been said, why can't the owner just sign the form? If everything's legit and we're already doing a form, what would it hurt to add a line for the owner to sign? Give the address of the destination. Give the adjuster's insurance phone number. Give these people something that they're asking for. If it was your car, you would want to know where to go and find it. If it was your car, you'd want to give authorization for it to be moved. You know, one of the comments on there was Texas is the only one that has a form for this type of thing. Yeah, Texas has it. Texas also has a lot more regulation in the towing industry than a lot of states do. So regulations to protect our citizens. So isn't this paperwork supposed to be about protecting our Texans? I think that's what we're here to talk about. Now I'd like to open it up if any other board members want to chime in.
I have a few comments that I would like to make. Number one, this form has been a problem since day one. I mean, I truly believe that it has. I, like Amy, believe that this form was really designed for consumers to be able to pick up their vehicle when they are a family member and that car is not in their name, or when they have a situation where they are a new owner and don't have any documentation to prove that. I think that we as TDLR and the industry has bent over backwards to make it easier for consumers to pick up their vehicles. We now release it with an insurance card that we don't question. This form is a great form for owners, family members, people along those lines, but I don't believe that this form was ever intended for insurance companies to use. That's the reason that we have the proof of loss claim form. That proof of loss claim form, I have not received one of those from an insurance company in more than 10 years in my VSF. And that is the form that really is intended to be used for this purpose. I also saw the comment that other states don't require this form. That's absolutely true. But I called a couple of friends in 2 different states this morning that are in the towing industry, and they said, we don't release anything without the owner physically coming and signing the release to let that insurance company pick it up, period. So that's the difference. In the state of Texas, we have tried to really go far beyond. I think there's a couple of key points here. Almost every one of the issues with this form results around an insurance company. That's really where the problems come in with this form. Almost every one of those scenarios, that car is going to either a shop that the owner is not aware of or not related to or not understanding who it is, or in many, many cases, probably 85 to 90% of the cases at my VSF, that vehicle is going to a salvage pool. And when that vehicle goes to that salvage pool, it came into my facility as a non-consent. It's completely protected and insured. We are here to monitor and make sure that vehicle stays in good shape. And it has all regulated towers around it, along with VSF employees that have been properly vetted. It then goes to a salvage pool that has absolutely no regulation whatsoever. There are no caps on storage. There are no caps on any fees that they charge. And I personally have had my vehicle wind up at the salvage pool under the contention that it was going to be totaled, and then later find out the insurance company was going to deny the claim. And what happened when I went to the salvage pool to pick that vehicle up? I was instructed to pay the fees. So that included all of the towing fees, all of the fees from the VSF, marked up, I might add. So those fees paid at the VSF, they marked them up because they paid it out for me. And then they began to charge me storage at not quite twice the regulated rate. And I was clearly told it's a consent situation. There's nothing you can do about it. And I can provide those receipts. This is clearly taking something from where the consumer is protected and moving them to a situation where they are completely unprotected and their vehicle could theoretically get lost without any of these checks and balances that we put in place to make sure that things are being done properly. Notices are being sent out. I, without doubt, have 2 customers every single month come into my facility and go, where's my car? Sorry, it's been moved. And I give them this copy of a VSF and they go, well, where did it get moved to? And I go, I'm sorry, I don't know. All I can tell you is this form is what I've got. Well, who do I call? I'm sorry. All I can tell you is there's a insurance claim number on the bottom, and they go, that's not even my insurance company. And I go, I'm sorry, there's nothing I can do. I even have created a form and given it to them to call TDLR and make a complaint. And most of those customers are like, I just want my stuff. I just want what I've got coming in my car. I want my gate opener, my garage door opener, whatever the case may be. I'm passionate about this form, and I hate to be over passionate, but this is a problem. The other thing is this form is falsified every single day. I can show you video of the salvage pool coming into my office with a form that's not properly filled out, doesn't have any information on it, doesn't have the vehicle information. I say, no, I'm sorry, we can't take that form. It has to be properly executed. They go, okay, walk out to my parking lot on camera. I can see them get in their truck, fill out a new one, walk back in and fill in all the blanks that I told them were wrong, hand it to me, and I give them the car. So this is not a representation of what the owner has instructed someone to do. I just don't believe that. And I believe it all stems around the insurance company situation. And don't get me wrong, I'm not trying to penalize the insurance company and keep the car for longer. I'm trying to help the reputation of the towing storage industry and protect these consumers. And I have my entire career done exactly that. So I've never been an operation that tries to keep people's car. That's all I really have to say.
My office is at the VSF, and I have the same exact experiences as Larry Turner said, Ken and Amy. It is it's very difficult to handle a situation when the customer comes up and we don't know what to tell them. And it's ridiculous that they don't know where their car is. They get all upset about it. And a lot of it comes down to, where's my property at? They're not even worried about the car. They're worried about the property, because when they go to the salvage pool, the car leaves here, gets on a record, goes somewhere else. You know, there are a lot of different people touch it. And who's going to be responsible if something's missing? If the car is here, I'm responsible. Well, once it leaves, I lose all responsibility for that. I was going to ask, I guess, Anna, is this something that we could discuss in a work group in a future meeting or something?
This is definitely something we can discuss further in a work group. Yes, sir.
I mean,
This is Mary Winston, Mr. Rash. I mean, I think you've read our minds.
Okay.
With the work group, because this has been something that's been discussed several times, and when we get it into a discussion of the whole board, we have some very passionate viewpoints, which are good to hear. But if we're gonna move forward, and this is a TDLR form, however, you all are the advisory boards, and we want to take your advice. And a work group is a time where we have a set of dedicated members of the board and staff to work through. Our chair today kind of read through some things she's been working on, and it would be her prerogative to choose those work group members. Not on the agenda for today, but we wanted to bring out this issue or concern for all the new members, and moving forward, that was our thought internally, that a work group would be a really good place to iron this out and get it more in a succinct fashion, to bring back, like Amy's done that with she's thought about this, she's written some stuff down. In a work group, we can have the back and forth with the staff, and then bring it back to the full board, and with those succinct recommendations, we can kind of move from there. So Mr. Rash, you read our minds. That's what we're, and I want everyone else to get a chance to express what they want to express, definitely, because that's why we brought it back up for discussion. But moving forward, as we move forward to our next meeting together, when we're looking for items, agenda items for next meeting, I think this is like top of the list, aside from updates from the legislative session.
Perfect. Thank you both for that, Charles and Mary. How about other comments from the board? I see heads nodding. Talk to us.
I just want to echo what many of the board members are saying. This is a concerning situation when the vehicle does leave a vehicle storage facility and we don't have the information to provide to the vehicle owner or the consumer. And I know that we talked about personal belongings and contents of the vehicle, that many vehicle owners are more concerned with those belongings and even the value of the vehicle. And there are circumstances that can, if I can put a real picture to this, you could have a situation where perhaps a parent, this is a true story, a parent with a child with the wheelchairs involved in a collision, and this wheelchair and medications and such are still in that vehicle. And without the vehicle owner's acknowledgement or knowledge, this vehicle is now processed through and out of this vehicle storage facility. To be able to face that family and be able to say, I don't have information where the contents of this vehicle are. We don't know where the vehicle is. That to me is not protecting the citizens as much as we could be. And I think that I would echo that having some information for vehicle owners of where is this vehicle going or headed, or their acknowledgement, will protect them at a further degree than we're capable of doing. At this point, we are to accept that form at face value, whether it's adjusted, refilled out, completed in the parking lot of our VSFs. We were to accept it at face value and have no further information. And we're just left holding this bag of working with a vehicle owner who's confused.
Okay, other board members, anybody?
I think Gary was trying to speak. He might be muted. Gary, you're still muted.
Can you guys hear me or no?
Yes.
Yes, now we can.
Okay. All right. Yeah, I was just agreeing with everything you guys were saying, and where Charles was adding that once it leaves our facility, we're getting people coming back claiming that we're taking the items out of the cars, but once we leave, they're in a unlicensed truck, tow operator, and then, as Ken was saying, the facility is not regulated, so they're coming back to us wanting us to replace the items or be responsible for them, and we can't be. And I agree with everything everyone else is sharing. All these, it's just ridiculous what we all have to go through daily with it.
Thank you, Gary. Okay, so James, you want to speak? I see you lit up there. No? No? Okay. So Charles made the suggestion of a work group, which I think is a great idea. Do I have any objections to a work group from any of the board members? Any reason why we would not want to do that? Yeah, I can only help, right? Okay, so Anna, can we assign a work group now, or do I have to put that on the agenda for next time?
Go ahead, Mary.
Sorry, Mary Winston here. Since it's not on the agenda, we can't assign right now, but we have time. And Amy, it sounds like you have a full board that wants to be a member of the work group. However, you know, we have to keep it under quorum. So you know how that goes, and you have some hard work to do to kind of quantify. You know, I think y'all have some pretty good suggestions. We'll see how it goes before the full board and how it works with staff. And I think with that staff input, that will be fantastic. So not today to be put on the work group or to assign the work group. We can definitely put that on the agenda for the next meeting. And those work group meetings occur between our actual board meetings. So once you make that assignment, you'll work with staff and you'll go from there. I feel pretty good about that because we have some good feedback. And I also feel pretty good about that because we do have some things that are priority coming up from this session. So this board actually has quite a lot to do. So this is just one more thing, and you all are up for the challenge, and I know that you're eager to get this on kind of taken care of, but this can definitely be put on agenda for next time. And Amy, you can, you know, start thinking about who you want on the work group.
Okay, super, good to hear. And you guys as well, if you feel led to be on that, let me know. Okay, so are we done with the discussion on the VSF 11? Does everybody feel fine with that? Okay, that's going to move us to agenda item H, guidance for tow companies and VSF operators to assess credit card swipe surcharges. I believe we have 2 public comments on this. Anna, are they with us?
Yeah, we have Joanne Messina and Larry Cernasek. Ms. Messina?
Yes.
Are you online?
Yes.
We'll go ahead with Mr. Cernasek. I don't, oh, I see Ms. Messina there. We'll go ahead with Larry Cernasek. Sir, you have 3 minutes to speak on this item. You can go ahead whenever you're ready.
Okay. Again, I want to thank the Chairman Figueroa and Presiding Officer Amy, the other board members, and the staff. Item H, about the credit card charge. I represent myself and the public who is not protected by, oh, sorry about that. We're talking about the charge here for the credit card. My experience has been that from different entities, like we go to city storage facilities that we have in the city of Pasadena, the county's charges for their registrations, it seems like a credit card fee of 3% would be an average of what I would think that we would need to charge to cover when people pay with a credit card. This is continuing to increase through different businesses that all charge a fee when you use the credit card. And some are higher than others, but to keep it where you're able to charge it, I think a 3% fee to add when they pay with a credit card would be acceptable. Thank you.
Thank you, sir. And now we have Joanne Messina online with us. Ms. Messina, are you there? I see you on mute.
Still muted, Joanne.
Can you hear me?
You have a sound on somewhere?
No, not that I know of.
If you have your phone on the meeting,
I don't.
or interesting.
I may
Okay,
be in the meeting twice.
you are. Michael, Mr. Fickle, if we could release one of Joanne. Okay, let's give it a try. I don't know if we released the wrong one. Can hear you now, but we can't see you. But we can hear you. Let's do this.
Okay, you ready? You can hear me okay?
Yes, ma'am, go ahead.
Okay, my name is Joanne Messina and I represent Southwest Tow Operators. I'm testifying on agenda item H, credit card surcharges. This is a longstanding issue with our members that we've been working on for several years, and we're very happy that TDLR is addressing this today. Under current law, tow companies and VSFs are required by statute to accept credit cards, but have been prohibited from passing these surcharges on to the credit card holder, even though many state and local agencies charge an additional fee for using a credit card. Our tow and VSF fees are highly regulated, so we're not able to increase our prices when our costs for fuel, insurance, or anything else goes up. The pandemic has hit all small businesses across the state very hard, and many employees lost their jobs. If we can start passing along the credit card fees to the cardholders, our members could put that money back into their businesses, even hiring staff back in some cases. We have one member who paid over $75,000 in credit card fees last year alone. We encourage you to allow our small business tow companies to pass these charges on to the cardholders, and we look forward to the discussion. Thank you for your time.
Thank you, Ms.
Yes, thank you, Joanne. We appreciate your comments. And Larry, we appreciate both of y'all dialing in for us today. Okay, I know many of us in the towing and VSF are very passionate about this because we do see the state and counties charging this fee, and here we're outside businesses and we can't. Let's open it up for discussion. Who would like to start?
Well,
Madam Chair, I actually have a presentation to make.
Oh my gosh, I'm so sorry, Elizabeth. You go ahead first. Sorry, Ken. Hold on.
Thank you.
Okay.
Thank you. And I actually think that based on the comments we've just heard, that this will be something that the industry likes, but of course I'm able to take questions and comments afterwards. So as you all know, because this is on the agenda today, we have reviewed the question of whether tow VSF licensees can charge consumers that credit card surcharge when consumers are using that form of payment. So for those who are watching who may not be super familiar, a credit card surcharge, which is also known as a swipe fee, is the amount that's charged to a merchant by a credit card issuer every time that card is used for payment. And as Mr. Sarnasek discussed, the surcharge is a percentage that's set by the issuer, and it varies depending on the type of card. So he was absolutely correct on that, that there are some that are lower than others and some that are higher than others. It just depends on the card and the card issuer at any given point in history, because just like our APRs change, those credit cards fees or surcharges, the swipe fees, can also change over time. We have previously issued guidance to the industry that you all may offer cash discounts as an incentive for consumers to pay with cash in an effort to try to avoid that swipe charge falling back onto you and having to absorb this. And so although we allowed for the cash discounts to be offered, we relied upon a section in the Texas Business and Commerce Code which specifically prohibited merchants from adding the credit card surcharge or the swipe fee to the total amount owed. And so this resulted in your industry and every other industry that uses credit cards having to absorb that credit card surcharge or swipe fee. Now, something interesting that has happened in the legal world is that in August of 2018, a United States District Court in the Western District of Texas here in Austin actually heard a lawsuit, a petition for injunctive relief by merchants who wanted to challenge the Texas Business and Commerce Code. And so what we heard in that opinion, and this court case is Rowell versus Paxton, for anybody who's interested in that. In that case, the court enjoined the state from enforcing the prohibition. So they said, you can't do this. And the reason why they said was because this was a First Amendment issue. So in that case, what the folks argued there, what the merchants argued there, who were mainly retailers, gas stations, and restaurants of that nature, what they said was that this actually wasn't an economic regulation as the state was asserting, but this was actually a violation of their First Amendment rights. And so the court looked at all of that and said, yeah, you know what? Merchants should actually be able to charge the charge and advertising that they are charging the charge to consumers and have consumers absorb that credit card swipe fee rather than the merchants. So because we have looked at that case and we've looked at it super closely and we've had a lot of conversations within the department, effective immediately, tow and VSF licensees may add the credit card surcharge to the total amount owed by consumers when consumers are paying with credit cards. And you may also continue offering cash discounts for consumers paying cash to continue to provide an incentive for consumers who may wish to avoid that charge. However, the surcharge may not exceed the actual percentage that's charged by the individual issuer. And you must also continue releasing the vehicles when the requirements under 16 Texas Administrative Code 85710, which are your release rules, are met. And so what that means for us and what that means for you is that we will begin reviewing what impact, if any, this new policy has on our existing rules. We anticipate that we will begin that rule review immediately, and we will be issuing additional guidance in the future. So we will take Mr. Cernasek's suggestion that he made, and we will incorporate that into our discussions about what a rule, whether a rule or rules are needed, and what that rule or rules should look like. And certainly it would involve a discussion on the percentage amount that's allowed.
Okay, discussion on this?
As you may know, I unfortunately probably have a lot to say about this. I have, as the president of our company, one of the things that I was taught when I was 14 years old working at a hamburger restaurant by the guy who owned it was, if you watch the pennies, the dollars will fall into place. So I am very adamant about that at my company, and I very much so pay attention to this. And I'll probably, I don't know that I understand credit card fees better than anyone else, but I have dug into it and spent several years investing a lot of effort in it. And to be able to have it as an exact pass-through is virtually impossible. If anybody's familiar with the interchange rates, there are about 80 different types of credit cards. Each one of them carries a different fee, and each one of them looks differently. And those interchange rates are the rates that MasterCard and Visa collects no matter what, no matter who your merchant processor is. So your merchant processor then renders that fee to MasterCard and Visa, the top of the pie, I guess you could say, and then they issue fees to you. And all of those include a per swipe charge, whether that card's red or not, whether that card charged is good or not, you still have a per swipe fee plus a percentage. And then the merchant processor that's in the middle has to charge a fee for them to make money. The smaller operation you are, the higher fees you're going to pay. The bigger operation you are, the lower fees you're going to pay. The big problem for small consumers like us is that we don't have that buying power like the Secretary of State does, or like a government does, or like a huge company that does, millions of transactions like a big retail giant. We don't have the ability to negotiate those rates down. So we typically will pay more rates. The other thing is those rates all possible for me to know whether you're paying at my front window with a Visa rewards card, but I can tell you as a consumer, and in our company, we use an American Express Plum card. 1.5% is our reward as using that card. It's passed directly to that merchant. So that merchant pays that 1.5% on top of what American Express gets and on top of whatever their processor charges them. So I'm just saying, I see it from both sides of the story. We need a percentage, and it needs to be It needs to be a dictated percentage so that we don't have rampant things going on around the state with people trying to figure out what their rate is. Number one, you couldn't figure that out instantaneously. We don't know that for 30 days until we get that statement. I really feel like we are in a situation where we lose. I'm a third-party storage facility. That means that the majority of the towers that bring cars to me, I'm not that company. I don't own it. So if I get an 18-wheeler that gets towed by the Houston Police Department because the operator goes to jail, the tow fee begins at $459. If I'm paying average 3% on that $459 that I get not one penny of, I pay it to the towing company, I just lost money. Additionally, I have a governmental entity fee that I pay to the city of Houston on every single tow that gets picked up, almost $21. I'm paying a 3% fee on that. Sales tax, I'm paying a 3% fee on that. So when you back up and look at what I'm paying this fee on that I never even get an opportunity to make a profit on, it's very unfair. And I've looked at rates from every consumer, from every merchant issue. Gas stations right now are charging an average of 3%, which is 10 cents a gallon on today's prices of fuel. There is also a big move for a company that is reverting all those processing charges back to the consumer. They quoted me yesterday a 4% rate that my consumer will get charged every single time that they run a card at my facility, but I will get charged nothing. So that consumer will get a receipt that says the total fees that they were charged by me and adds a 4%. They're calling it a convenience fee to that consumer if they want to use it. And this company is signing up retailers right and left and looking at our industry as a prime place to go for because they feel like they do not meet this requirement of having the strict restriction that we have. So I welcome this fee. I don't believe that we can come up with a number that will cover all of our fees, but I believe that we can recoup on an average enough of it to keep us in business and stop us from losing I truly feel like we're just bleeding money every time that someone uses a credit card at our facilities. It's really unbelievable the amount of fees that we pay and how people don't understand how those fees work, including myself to some degree in some different aspects of this.
Madam
Sorry
Chair.
for being so passionate about this issue too, but it's an issue that really hits home for me.
Madam Chair, if I may just clarify something about the case that I cited. So I've heard a couple times now, not picking on you, Mr. Ulmer, and not picking on Ms. Messina, our previous commenter, but I've heard the use of the word profit. And so I just want to clarify that the judge in this ruling was very specific that the ability to charge the credit card fee is exact, and that credit card fee charge the consumer should not absorb in excess of what that fee is, and that this is not a profit-making situation. This is not a time for businesses to try to recoup losses that they are taking in other areas. So the judge was very specific on that point, and so that is why we have said that you cannot charge in excess of what you're actually being charged by the issuer.
And let me clarify, Elizabeth, when I said profit, I meant the fact that we are losing money when we accept a credit card for fees that we don't get to receive, such as the governmental entity fee, the sales tax, the towing fee that we pay to a third-party towing company. Those are the things where I'm saying I certainly am not looking to make a profit off someone using a credit card. I'm just looking to recoup the fees that I am being charged by these merchant processors who are in the middle collecting the money for MasterCard and Visa and all of those types of things. The other part of this is, and something that has to be considered, is the sheer cost of implementing the credit card process across the board. So the equipment that we use in our office, which gets damaged on a frequent basis, which gets, when we have this last storm that we had, damaged some of our equipment because the power kept going in and out, and it wound up blowing out one of those pieces of equipment. That's $1,000 device that we have up there to be able to run that credit card. And under the new rules with all of this encrypted information, it's not something you can go out and buy on eBay and replace. I mean, it has to be encrypted by the company. So these costs are much more than just the fees that are associated with the actual swipe. There are lots of other fees that we all are adhering to. The PCH compliance fee. I mean, there's a fee there for us to prove that our system that we have in place at our VSF meets the federal compliance rules for chip cards. I mean, that's a fee that we each pay every single month. That's not associated with a direct credit card charge, but it's charged by that merchant processor under federal rules to make sure that we're compliant. So believe me, I wasn't suggesting we were to make a profit on it.
Right, and I certainly understand, and thank you for explaining that further and for providing some insight into the additional fees that you all face, and we certainly understand that. But in our authority, what we have the ability to do today, the best we can do today, is say, in line with that court decision, you can charge the credit card fee back to the consumer. That fee, whatever it is, if it's 1.4% or 3%, whatever the fee is associated with that card, that is what we charge. And again, we will be reviewing the rules. And Ms. Milstead, this could be one where you may discuss a work group.
Okay. How does the department plan to watch this, keep over this? I mean, that sounds like a huge undertaking. Can you talk about that?
Not at this time. Those are part of our internal discussions, and we talk with enforcement on how this could be enforced or would be enforced. I've also spoken with our field operations, field inspections folks about their role in this. And this will be something that is an agency-wide effort, and it will be something that you will see in rule, I think, really. I don't think there's any way out of a rule, but I can't say that certainly that there will or won't be a rule. What I can say is we're having extensive internal discussions on the enforcement end of this and the inspection end of this, and how we would be monitoring to ensure that someone is not taking advantage of a consumer and is being fair to the consumer about the charge that is being charged back to them.
Okay, so to make it clear for all of the people that are listening and all the board members that are here, as of today, we can start charging that fee of what we pay. We can start charging the consumer now.
That is correct, but the fee cannot exceed what you are actually paying.
Yes, ma'am. Okay. I hope everybody's.
Can
Go
I
ahead,
just
Ken.
add a little bit more? I truly believe, and believe me, I believe in this fee 100%. But I believe we are opening a nightmare regulatory issue, and we are going to get VSFs in trouble because it is virtually impossible for them to figure out that fee on a per transaction basis until 30 days later. And it just is virtually impossible for them to know which card they're actually being run at the window. I truly think as a service to the VSFs that we represent and the towing companies that we represent, especially these mom and pop operations that don't have the ability to look at this and figure it out. I'm a big operation and I can't figure it out. I've been working on it for a couple of weeks and not been able to figure out those numbers. And I just think we're doing a disservice to them if we don't have a regulated percentage, something that TDLR has recommended, something TDLR has put into rule. However we do that, it needs to be a standardized fee because, and I'm not looking to recoup all of it. I understand that we probably will not recoup all of it because some of those cards are at a huge percentage, some of them are at a low percentage. All I'm saying is, if we don't develop something, we are going to put these VSFs in a position where they're going to say, well, it looks like my rate's 2.8%, and that's what they're going to start charging. And then first thing you know, they're going to have an influx, or they're going to have more cards of a low come through, and they're not going to meet that criteria for that month, but they're not going to know for a full 30 days. So then what do? Go back and give each one of those people back 20 cents? I mean, it's a catch-22 that's going to cause problems. Us developing a percentage and saying this is the number, it's not going to make everybody happy because they're going to go, well, my percentage is more than that. But we are doing them a disservice if we just say, okay, it's out there, we're going to throw this to you and you collect what it's a pass-through. So you
Okay.
figure it out, however you do that. I just
Right.
think we're really asking them to get in trouble. I really do.
So let me please clarify that when we say that beginning today, you may charge this fee, it is a may. It is not a must. Every individual business will make a decision based on their business model and what works best for them. And so when we say may, it's permissive, and the industry can decide, each individual business, what works for them until the guidance is released. It's the best that we can do for today.
And believe me, I'm not criticizing you guys at all. I thank you so much for recognizing this and putting it out there for us to discuss. So I'm not criticizing you at all. I'm just saying, you know, I really want some direction from TDLR because I just don't want another avenue for possible violations. You know, I feel for those, all VSFs, myself included, but as a chairman of TTSA, I just don't want to put our members in a position. I've gotten 100 phone calls on this already, and they've all asked me, what can I do? What can I do? And I'm like, I don't know what to tell you. I mean, I don't want to tell you something and it be wrong. And that scares me. You know, I really want a number that TDLR condones. I understand the problems with doing that, but it's a really scary area to go into.
So, Mr. Omer, Mary Winston here. I appreciate you giving us the other side of that, because there are a lot of costs that are associated with it. And I've taken notes because, you know a little bit about the way the practice works, but you really don't know all of the costs. And so you're right, that would be a monumental task for us. I don't know that we could figure it out specifically, but we're going to work on what we can do. But what we know today is that we can charge something, but not more. We can charge, some of the fee, definitely not more. So that gives some bandwidth. And as Amy said, can we do this today? Yeah, you can. But according to this case, you can. But to have rules that would give a more uniform fee that wouldn't be more than, but would be something, definitely not recouping all of the costs that you as a professional are having to incur. Mr. Chernisek suggested 3%. That's something we can look at. That's something that our general counsel's office will take into consideration. And because of on this one, we've already requested a work group if we want to kind of work on that with staff. Am I correct, Elizabeth? Yeah. So, okay. So I'm going to hand it back over to her.
Mute, and then I couldn't figure out how to take it off mute. So I believe that a work group would have to be put on the next agenda, if that is what Ms. Milstead would like. However, that does not mean I will not start working on this pending a work group. This becomes a priority for me on my workload with regards to TOW VSF. And so by the time you get a work group into place, hopefully I will have a better view of what I think the rule probably needs to encompass, so that we at least have a starting point when we get into the work group.
And Mr. Ulmer, and members, this does not mean, as well as members of the public. I'm not going to request that you bombard miscellaneous strip matter, but I am requesting you bombard advisory.boards@tdlr.texas.gov. And we will take in all of those emailed suggestions or thoughts on this situation. And don't copy other people, just send it to us because we don't want to run into a quorum situation or violation of a quorum. And we can forward that to our general counsel's office, to Ms. Stripmatter, and she can incorporate those things and those thoughts as she's working on this. It's good news in a lot of ways, I think, but I know it's not quote unquote enough. It's not going to be a 100%. I mean, if your machine breaks and that's $1,000, sorry, that's not going to help a lot. But it's something that, according to the courts, we can get passed through fees. It appears, thank you, Mr. Omer, for your education in this, educating us that we may not, it's kind of impossible to get that 100% correct, but I mean, Mr. Cernasek obviously knew that as well. He's like, how about 3%? You know, so we're not going to come up with an arbitrary number, but we want to come up with something that the board considers fair, that does not exceed the cost that goes to the consumer. So all concerns or thoughts on this, members, please email advisory.boards@tdlr.texas.gov, and you can put in the info line or what a subject line, you know, credit card fees or whatever, tow VSF credit card fees. And we read them anyway. And there are several of us who have that box and we'll catch them anyway. But we are soliciting your thoughts on this as
Mary,
we move forward.
if I may just, one bit of information that I will not get unless people start telling me is, what are the rates that you are paying on those swipe fees? What is the low end? What is the middle? What is the high? What is your average? Because that is information that you as the merchants hold that TDLR does not have. So that's going to be very important information for us to gather as we move forward, so that we aren't just randomly picking a percentage. So our percentage is based on some reasonable amount of information that has been provided to us by people in the industry itself.
So I think that's really important for our listeners. If you're listening to our meeting today, we need participation from each and every one of you guys, because we don't always get the participation we need from the industry when it comes to things like this. So if you have that, please send it to the email that Mary gave out. I know that that's very important to all of us. We're passionate too, just like Ken. So we've got to do our work as well. Any other comments on this discussion?
Can you hear me?
Yes.
Okay. This is another question for those, and may help those that are out there listening. If you choose to go ahead and start charging the fee now before this work group is set up, Ken mentioned some of these credit card processors that are showing the fee on the actual credit card invoice, but that amount is different than your actual tow invoice. Are those okay to use? And does the processing or convenience fee, whatever terminology you want to use with it, does that need to be listed on your non-consent tow invoice? And also, would that have to be a thing that's added to the sign? Some of that's to be discussed in the work group, I'm sure, but if people decide to start doing it now, does it need to be listed as a fee on your non-consent tow invoice if you're charging it?
You could, if you wanted to do it, you could start doing that now. You don't have to. The rules will dictate what has to be done and what cannot be done. For now, since there are no existing rules, you can choose to show it, or you can choose not to show it.
Okay, that was my question, because a lot of our members have been fined for charging it previously, and so that's what I wanted to know, if it needed to be on the invoice or not. So, okay.
And I'm sorry for taking up so much of everybody's time on this issue and being so passionate about it. But one thing I would caution TDLR about is to Google rates for credit card processors, because it is a loss leader. They will quote that they are going to charge you 1.5%. And then when you actually sign the merchant agreement, it's clear in there that there's also a per swipe charge. There's also the interchange rate that you will pay on top of that. Your equipment fees and things like that are written into this, and monthly fees that are on those merchant accounts. So there are lots of places that they get fees. Almost every one of the interchange rates has a % transaction fee on every swipe. And that means even if that card is declined. So a customer could try 3 cards and you get charged 22 cents for each time they swipe it, even though you never actually got one to be approved. So there's lots of fees. If a customer decides to do a chargeback, which means they tell the credit card company, hey, I didn't get the service I thought I should receive, there's a $35 fee for that to us as the merchant. And when that $35 fee is assessed, we don't get that money back. I mean, that $35 fee is in many cases above. I mean, think about it. We get the first day storage. that's really where we look to get some money, and that's a lot less than $35. So there are lots of things. Don't just look on the internet and go, oh, well, these merchant processors claim that it's only, this tiny percentage, because that's not a real merchant agreement.
Okay, thank you, Ken. Any other discussion from the board? Okay, it's my understanding that we cannot form a work group here. We have to put it on the agenda so that we can form it for next time. Is that correct? Okay, so we'll move past that. All right, my stuff here says now we're going to hear from Elizabeth Salinas on education and examination work group update.
Yes, so this will be pretty brief. So we have scheduled a second meeting for the education examination work group for next week. During our first meeting, I was asked to look into whether programming within TDLR could make a particular thing happen. And I have spoken with our IT people, and I have that response for our work group. What I anticipate will happen after I provide that information to the work group is then they will decide whether they want to put any proposals forward to the board for consideration on amending the CE requirements for tow. So at this time, I don't really want to get into specifics about the discussions that we've had to allow the continued free flow of ideas in the work group to kind of sort of form what it is they want to propose, or whether they decide not to propose anything. But we do have a meeting next week, and I anticipate at the next board meeting, you will know for certain whether they would like to propose some changes to the CE requirements for tow licensees. And if they do want to propose some changes, what those changes are and how we would move forward in making that happen, and whether there needs to be any rule amendments.
Okay, thank you, Elizabeth. We appreciate that. Okay, I'm going to chime in here if I may, Anna, if it's okay. I kind of wanted to give a little update on legislation as far as what we're doing on the other side, what our associations are doing. Is that okay? Okay. So there's been 6 privacy bills filed concerning motor vehicle registrations. We're going to do what we can to work on those. There are 4 move over bills that are adding pedestrians, construction, and bicycles to the move over rule, meaning you'll have to move over for those bicycles, pedestrians, all that stuff. So these things are on legislation's list, so they're working on these. There's 2 new lien bills. One is going to add a self-service storage and other cleanup to the auto repair lien process. There's 2 of those coming down the line. Tow bill that's going to change the terminology of the word accident to crash in the statute. One bill is trying to remove tow trucks for salvage pools out of TDLR regulations. Several bills are trying to help with unwarranted lawsuits against trucking, and includes tow trucks and all commercial trucks and vehicles. TTSA organization is spending most of the time trying to help with get these out of control lawsuits that exist and putting small businesses out of business. I don't know if you guys know this, but Texas is the #1 in tractor trailer accidents in the United States. We have been since 2016, so you can imagine the lawsuits that are affecting the towing industry there. There's a bill that's been introduced to regulate the drop fee to a $50 statewide fee. This is the fee that tow companies charge when they go to tow a vehicle and then they end up not towing it, such as a private property tow, and they have to set the vehicle down. The department currently allows us to charge, I think it's half rate, and this would change it to a $50 fee, not a half rate anymore. Closing date, like you said, was March 12th, Miss Mary, and so we'll see how these all pan out. I encourage you to watch your legislation and do your bill tracking. Okay, that's all I have to say on that. Anybody else have anything to chime in on legislation? Okay.
Sorry, I wanted to chime in, Mary Winston, that we are also, you've given us some here and look at our webpage, and we should have those listed. And in our list are live links, so you can go out and read each one of those bills. And I wanted to say one other thing. We do have a rules work group that could look at these fees. Now, I've made a mass request of everyone, email us. We want it all. But if we could get on the members of that rules work group, since it's already assembled, do we have the members, or have those members left the board?
We do have those members. Let me look and see who they are. So we would need to reassign the roles members that we have currently are Tasha Mora, Kyle Jackson, Amy Milstead, and Joanne Messina. So we would need someone to replace Joanne.
Okay. So that, Amy, I just wanted to kind of, because we had such a really robust discussion on that. We do have that rules group. If you wanted something less Wild West, that I'm saying, everyone send us what you want. If because I know Elizabeth is ready to work on this. If you want that rules group that's already assigned to look at the credit card surcharge fees, give some research, that would be okay.
I think that's a great idea. Kyle, Tasha, do y'all have any objections to that? Can we get started on that?
Not necessarily an objection, just wanted to kind of clarify. Sorry, this is Kyle Jackson. With the legislative session going on, my schedule is like very, very in flux on a daily basis. So I just wanted to throw that out there in case maybe want to pick somebody with a little more of a stable schedule, but I know everybody's schedules are crazy, so no worries. If not, just making that caveat real quick while we're talking about it.
And I cannot appoint someone to replace Joanne Messina at this time, can I?
Actually, that's you can start with what you have right now. And we can also take those comments. I don't want to step too far out from our agenda and get my hand slapped back. But I just want to make sure we can proceed with just having everyone comment. But I did kind of message in the background, do we have a group that could already handle this? And we do have a group that could, but I wasn't sure of the members. And it does look like we do have some former members and members who, this session is just very busy. And so this also we can do the universal approach, and you can reappoint or get those appointed at the next meeting, Madam Chair.
Okay. All right. Well, we'll move forward on that and see what we come up with. Okay. Thank you. Okay. So that takes us to recommendations for agenda items for the next board meeting. I'm going to start it out with VSF 11 form and credit card fees. We'll go from there with Elizabeth giving us her feedback and her research on that. What else?
An update from the session.
Oh, yes.
Yeah, those bills you mentioned and any others.
What else? Anybody have anything else to add? Elizabeth, have we covered everything that we need to?
I'm getting a message that you need to put on the agenda to add a work group, any work groups that you're wanting to do.
Okay, PSF 11 form and then credit card work group if we need to adjust or amend.
Yes, ma'am.
Ms. Anna, looks like you got that. Anything else that we need to add?
The education and examination work group update, because we're going to have a meeting next week.
Yes, that's right.
Thank you, Charles. Is that it? Okay. Discussion date and time for the next meeting. How quick can we have this thing?
That's awesome. Kyle is not free. Kyle is busy. No, just Let us poll the board after this meeting for our next board meeting.
Okay. Elizabeth, we're not under any time restraints or anything. There's the rules done, that kind of stuff. So we're good.
That's right. So the next commission meeting, I will be presenting it for adoption. Hopefully the commission will pass it, and then we look at a June 1st effective date.
Can you tell us when the next commission meeting will be?
Is it May 5th or the 6th, Mary?
6th.
May 6th.
Okay, sounds great. Okay, so we'll get our date and time at the next meeting. I would like to thank staff for all their hard work. I'd like to thank Mary for joining us, and also Commissioner Figueroa. Thank you all. Y'all help make this meeting a lot smoother for those of us that aren't so suave in all this. If there's no other comments, questions, concerns, I need a motion to adjourn.
I'll make that motion.
Of course you will, Ken. Can I get a second?
I'll second.
Perfect. Thanks, Tasha. Okay, do we need a roll call to adjourn, Anna?
No, ma'am, you're good.
Perfect. Okay, meeting is adjourned. Thank you all. Have a great day.
Thank you, everyone.